Keeping a boot on a vehicle while waiting for an owner to take a safety driver course will create operational concerns for DPW. Once a vehicle is booted, it will be moved from the street after 24 hours and be impounded and will begin to incur storage fees. Also, the legislation does not define how and when DPW will be modified in vehicles to notify the vehicle have successfully completed the course. Owners have up to 28 days to reclaim their impounded vehicle before it's either auctioned or scrapped. A safe driving course would need to be successfully completed before the 28 days have passed. DPW have no position on the bill provision that D.C. Attorney General may bring a civil cause of action in D.C. Superior Court against any motor vehicle operator for immobilization of a vehicle. However, we also question how DPW will be notified of any court order obtained or how to locate the vehicle in question. Again, DPW's system is vehicle-driven, not person-driven, so this would not be workable. DPW does not support the 30-day grace period within which the individual may complete a safe driving course before booting their vehicles. First, this section may be a conflict with the previous section requiring a person to complete a safety driving course before a vehicle can be removed and waiving the booter fee that the person successfully completes such a course. In addition, it is highly unlikely that a vehicle which is boot eligible will still be located on the street if the owner knows that they have a 30-day grace period in which to complete a safe driving course before the vehicle is booted. Regarding the provision that any notice of infraction that may result in suspension or revocation of an individual's operating permit shall provide notice to the individual potential immobilization of their vehicle, this is also unworkable because a single infraction will not make a vehicle boot eligible. Only 2 unpaid tickets more than 60 days old would make a vehicle eligible for booting. Although DPW understands the council's intent for introducing Bill 25-425, we have serious concerns about the bill. However, we are amenable to working with the council to achieve the bill's goals and make it much more workable. In summary, DPW generally supports any additional measure that will take dangerous drivers and repeat offenders off our streets in order to improve traffic safety. We appreciate the council's efforts in proposing legislation to achieving our mutual goal of safe travel along our roads. Thank you for allowing me to testify today regarding this bill. I am ready for your answers or questions.
Thank you very much, Director Spriggs. Next, I believe we have Director Robinson.
Thank you so much. Good morning, Chairpersons Allen, Nadeau, members and staff of the committee. I am Gabriel Robinson, Director of the D.C. Department of Motor Vehicles, and I am pleased to testify before you today on Bills B-25-421, the License Suspension Reform Amendment Act of 2023, B-25-422, the Automated Traffic Enforcement and Effectiveness Amendment Act of 2023, B-25-425, the Strengthening Traffic Enforcement Education and Responsibility Steer Amendment Act of 2023, and B-25-435, the Fraudulent Vehicle Tag Enforcement Amendment Act of 2023. The Department of Motor Vehicles is pleased to have the opportunity to work with the committees on these bills to ensure they achieve the goals of addressing driver behavior and keeping our roadways safe for all that travel on our roads. DMV welcomes the chance to partner with you on advancing policies in support of enhancing public safety, which is a key component of the agency's mission. It is critical for those who travel on our roadways to do so in accordance with the rules of the road. DMV is focused on saving lives every single day. To that end, I know the committee have concerns about the communications between DMV and DC Superior Court. I can say confidently that we are working diligently with Superior Court, the Office of Attorney General, Metropolitan Police Department, and the U.S. Attorney's Office to put processes in place to ensure DMV systems and D.C. Superior Court systems are talking to each other consistently and accurately. We have increased quality checks to ensure that we are receiving information from D.C. Superior Courts and the information they're sending to us electronically on a regular basis. Additionally, DMV is taking actions against driver privileges, those who have been convicted of DUIs, DWIs, and other major moving violations. Now I will address DMV's concerns about the proposed legislation before us today. As proposed, Bill B-25-421, the License Suspension Reform Amendment Act of 2023, would require the suspension or revocation of an individual driver's license or vehicle registration upon being charged for a number of enumerated offenses, including drinking and driving. This bill will also affect individuals who have been arrested and charged in the District of Columbia only, since the DMV does not receive information from other jurisdictions about licenses until someone has been convicted or administratively found liable. The bill would also require major reprogramming to DMV's database, as we also do not have a connection with OAG at this time. So we would need that information from OAG to be notified when someone is charged of a specific violation. The bill also raises serious due process concerns as it relates to the taking of individual license and registrations without either a hearing or some type of administrative review. While the bill does allow for reinstatement of licenses and vehicle registration if the individual is not convicted, reinstatement can only occur upon payment of a reinstatement fee. From an equity point of view, this seems to be unfair to an individual who may not be found guilty of the charged offense and would be responsible for paying a reinstatement fee. This will put undue financial pressure on low-income residents. It will also directly impact anyone in the household because an individual, as soon as they are charged with the violation of something that they may not be guilty of, the vehicle would be unavailable for anyone in the household, unfairly burdening those who are innocent. Additionally, the proposed amendment to 18 DCMR subsection 301.1 requires the permanent suspension of an individual's driver's license and vehicle registration upon receiving a record of someone's conviction for a variety of violations, including drinking and driving. This approach seems to be contradictory to the mandatory requirement for DC licensees to enter into the Ignition Interlock program upon being convicted or administratively found guilty of drinking and driving offenses. Unfortunately, all too often, those whose license have been suspended or revoked for drug and alcohol violations continue to drive. At least with the Ignition Interlock program, there is less of a chance of them to be driving while impaired. DMV also has concerns about vehicles that are owned by more than one person. If the vehicle registration is suspended, then the co-owner of the vehicle will also be unable to drive the vehicle. Also, this bill does not account for vehicles owned by an organization, trust, or some other entity. Vehicles in these categories will evade elements of this bill. Next, I would like to discuss DMV's concerns about the proposed changes relative to Bill B-25-422, the Automated Traffic Enforcement Effectiveness Amendment Act of 2023, including but not limited to points assessment and liability, notification to insurance carriers, and reducing the time in which one will have to vacate a deemed admission of liability based on certain offenses or defenses. Currently, points are not assessed for automated traffic enforcement ATE tickets, which are commonly referred to as photo enforcement citations. The proposed amendment is also recommending that these points be assessed automatically for these tickets. If passed in its current state, DMV will likely have a large influx of traffic adjudication submissions, as drivers will have a greater incentive to contest these tickets, and they will also have a variety of questions as it relates to their license. There are two potential major concerns with assessing points to a driver's license for ATE tickets. One is the proposed legislation would require assessments of points against the owner of the vehicle. If there is more than one owner, the primary owner will be presumed the operator and assess the points. The proposed legislation further states that the primary owner could rebut the presumption by sufficient evidence. Since the district has the burden of proof by clear and convincing evidence, the primary owner need merely to state that they were not driving the vehicle in order to have the ticket dismissed. Additionally, as stated in respects to Bill 25-421, the bill does not account for vehicles owned by an organization, a trust, or other entities that's not an individual. Further, it should be noted that a resident does not need a license to title or register a vehicle in the District of Columbia. A resident who has a non-driver identification card may title and register a vehicle in the district. So this bill will have no impact on this population, as points cannot be assessed on a non-driver identification card. The fact is also true for vehicles that are owned by organizations, trusts, and other entities. The other major concern is the assessment of points will only affect drivers licensed with the DC DMV, because DC residents are the only drivers that the DC DMV can take this type of action against. Out-of-state drivers would not be subject to points, as the driver is not identified for ATE tickets. Additionally, the jurisdiction of the license holder can impose points on their licensed drivers, or is the only person or entity that can impose points on their drivers. And other jurisdictions are not likely to impose points on a driver who have not been positively identified. The proposed legislation further provides that the director may waive points for moving violations after the person have completed a traffic safety course. Present legislation allows hearing examiners to waive points if an individual can show good driving behavior and successfully completes traffic school. Several jurisdictions allow for automatic traffic schools for certain violations, thus avoiding the adjudication process. We would like to work with the committee to fine-tune this proposal. This bill also proposes that the DMV director would send a report to insurance companies 2 times per year with the names of vehicle owners who have 5 or more outstanding moving violations within a 6-month time frame, along with a copy of the driving record. The insurance industry, is concerned about the legislation structure as proposed in this bill for the DMV to submit or transmit reports to carriers does not match up with how they currently receive information about drivers. Carriers are required by law to send DMV information on their full book of business. The DMV does not send information to carriers in this manner. Additionally, when carriers need a driving records, they are assessed a fee. DMV has ideas on how to make this information available for carriers twice a year without DMV having to send it to them directly to the carriers. However, it should be noted, this information will only be useful in a useful format for DC registered vehicles, as carriers can take action. Another concern is the reduced timeline to vacate a deemed admission of liability of ATE ticket. Right now, vehicle owners have 1 year to file a motion to vacate a deemed admission on the grounds that they were not the owner of the cited vehicle, or their vehicle or tags were stolen. With this proposal or this amendment, the time will be reduced to 60 days, which may not provide individuals with ample time to collect documents necessary to mount a strong defense. Next, I will turn my attention to Bill B 25-422, Strengthening Traffic Enforcement Education and Responsibility STEER Amendment Act of 2023. As proposed, DC Official Code subsection 50-2203.01 would be amended to require suspension of DC residents' driver's license, or suspending of driver privileges for non-DC residents upon being charged for vehicle homicide in the district. This raises serious due process issues pertaining to actions against a license or privilege to drive without either a hearing or some type of administrative review. It is imperative that an individual is given a meaningful opportunity to be heard on the suspension of their license or driving privileges. During the public testimony on October 4th, 2023, Director Parks, the Executive Director of the Criminal Code Reform Commission, raised the same concern about the lack of due process regarding suspensions based upon the individual being charged with certain offenses. Unlike the Driver Suspension Reform Amendment Act of 2023, this bill does not address reinstatement of the license if an individual is found not guilty or the charge is not proceeded to trial. The suspension will only apply to charges of vehicular manslaughter in DC, as DMV is not notified of charges in other jurisdictions. This proposed change would require new integrations with OAG to allow for notification when drivers are charged with this offense in the district. The bill also proposes amending DC Official Code subsection 50-2201.02 by adding several definitions, including immobilization eligible offense, which includes when a driver has been found liable or guilty of several offenses. The offenses noted includes 8 or more infractions where the driver is alleged to have traveled at speeds of 10 miles per hour or less in excess of the speed limit, and 6 or more infractions where the driver is alleged to have traveled at speeds of 11 miles an hour or more in excess of the speed limit. The department would appreciate clarification on this proposal, specifically whether it intends to include ATE violations, since the proposed includes the word driver and not owner. Subsection 9901.1 of Title 18 of the District of Columbia Municipal Regulation defines driver as a person who drives or is in actual control of a vehicle or bicycle. Since ATE tickets are issued to owners of the vehicles and not the driver, clarification is needed. This bill proposes to amend DC Official Code subsection 50-2201.03K by calling for immobilization of vehicles when the owner is found liable or guilty of any immobilization eligible offense. DC Superior Court currently has jurisdiction over reckless driving and aggravated reckless driving violations. Therefore, if a vehicle can be immobilized when an owner is convicted of either, DMV would need pertinent information about the driver and vehicle to execute the immobilization request. Furthermore, the proposal provides for the waiver of the $75 immobilization fee once the owner has completed a safe driving class. It does not address potential impoundment or storage fees. DMV seeks clarification on the waiver of those fees if the owner completes the class after the vehicle has been impounded. Additionally, the immobilization of the vehicle may impact the owner who is operating the vehicle, as well as those who rely on the vehicle, including a co-owner who has not been charged or convicted, or other family members or members of the same household who use the vehicle for transportation to and from work, school, or medical appointments. The STEER Act proposes to amend DC Official Code subsection 50-2201.04 to lower the threshold of reckless driving to include speed violations traveling 20 miles or more over the speed limit, and adds additional actions that would be considered aggravated reckless driving. Currently, DMV is responsible for adjudicating speed violations of 20 to 29 miles over the speed limit, while Superior Court has jurisdiction to adjudicate reckless driving and aggravated reckless driving charges. Lowering the threshold of speeding for reckless driving would transfer those cases to DC Superior Court. DMV seeks clarification on how the agency will also handle out-of-state convictions for speeding 20 to 29 miles over the speed limit. The proposed changes of DC Official Code subsection 50-140301 are more lenient than the current requirements for suspension and revocation of DC license holders or of a non-resident privileges who drive in the District of Columbia. The proposed legislation provides for the suspension of an individual's license when there are sustained or final determination of liability based upon conduct within a 6-month consecutive period for the following violations: 8 or more infractions for speeding 10 miles per hour or less over the speed limit, 6 or more infractions for speeding 11 miles per hour or more over the speed limit, 2 convictions of reckless driving, or 1 conviction of aggravated reckless driving. Currently, 1 conviction of reckless driving or aggravated reckless driving carries a mandatory 6-month revocation for the first offense. The points assessed for speeding violation may vary by the number of miles an individual is traveling over the speed limit. The minimum number of points for speeding is 2 for traveling 10 miles or less over the speed limit, and the maximum number is 5 for traveling 21 miles over the speed limit or more. Under the current point system, one could have their license revoked well before the requirements listed in the STEER Act. Also, under the current point system, the revocation of the license or assessment of points is based on a ticket given to the actual driver of the vehicle, not ownership of the vehicle. The driver is held accountable for their driving behavior. The provision provides for suspension based upon 6-month consecutive period. The DMV also seeks clarification for this period. Is it a rolling time frame? Also, what happens if there is a suspension and then reinstatement? Does the 6-month period start again? If the proposed suspension system includes ATE tickets, then only DC drivers will be affected by the proposal. Since ATE tickets are issued to vehicle tags, DMV does not receive driver license information about the owner or driver for an ATE ticket issued to an out-of-state license plate. Additionally, if DMV was able to obtain the driver license information of the owner of the vehicle licensed outside of DC, other jurisdictions would not take reciprocal action of suspending the owner's driver's license because liability is based upon ownership of the vehicle. DMV has concerns about Section B of the new proposed provision, subsection 50-1403.1, that requires agencies to deliver either the suspension of a license or the immobilization of a vehicle for 30 days to allow individuals to complete a driver safety course if convicted of reckless or aggravated reckless driving. As noted above, convictions from DC Superior Court for reckless driving or aggravated reckless driving requires revocation of a license for 6 months. This new provision is in conflict with the required mandate to revoke the license. DMV also seeks revocation to the amendment of the Motor Vehicle Service Fees and Education Support Act of 1982. The new section, Section 10, provides that completion of a safe driver course can be used to satisfy any outstanding fine. However, most fines are not answered timely, would include additional penalties and fees for services like collection. DMV requests clear guidance on which portion of the total amount owed will be covered by the waiver program. DMV supports the amending of DC Official Code subsection 50-1501.02 to require MPD to notify DMV of stolen vehicles. DMV requests that in addition to providing the make, model, year, and plate number, the vehicle identification number should also be included. Additionally, because a vehicle owner is not required to have a driver's license, the provision should include either a driver's license or non-driver identification card number. DMV would further suggest that MPD notify DMV when a stolen vehicle has been recovered. Now for Bill B 25435, DMV agrees with the issue of fraudulent tags that needs to be addressed and welcomes the opportunity to partner with you on advancing policies in support of enhancing public safety and ensuring that all district residents who own vehicles have properly titled and registered vehicles in the District of Columbia. Thank you for this opportunity to testify, and I look forward to your questions.
Thank you very much. And then last for our government witnesses, let me turn to Interim Director Kirschbaum.
Good morning, Chairperson Allen and Nadeau, members of the committee, and staff. My name is Sharon Kirschbaum. I'm the Interim Director of the District Department of Transportation, commonly referred to as DDOT. I'm here today to present testimony on behalf of Mayor Muriel Bowser on the 4 traffic enforcement bills previously referenced by my colleagues. Improving traffic safety is DDOT's top priority. It is the first goal outlined in the district's long-range transportation plan, Move DC. DDOT works diligently to implement various traffic calming measures, including road diets, curb extensions, traffic control signals, and speed humps. Enforcement also plays a critical role in mitigating dangerous driving. As such, DDOT is collaborating with other agencies and with the Council on the Automated Traffic Enforcement Equity and Safety Task Force. This task force has done research to provide recommendations on the district's ATE program and other moving violation policies, including the fine schedule and financial penalties for late payments. As the interim director of the agency that operates the district's ATE program, I will focus my testimony today on the ATE Effectiveness Amendment Act of 2023. We are proud of our ATE program. In 2021, we conditioned a study of the program, which revealed very positive results. Across all 29 studied speed camera locations, after 12 months of installation, speeding decreased overall, injury crashes fell by 30%, and overall citations dropped by 1/3. We have found that about 70% of cited vehicles only received 1 citation. Our cameras cite less than 1% of passing drivers, meaning they have a 99% compliance rate. Put simply, DDOT's ATE cameras work, and they keep our streets safer. DDOT welcomes new approaches to make our fines more equitable and ensure they are creating long-term behavior change. However, we have concerns about operationalizing some of the provisions in this bill. First, as referenced previously, assessing points against a driver for ATE violations in the district would pose challenges based on how we operate the enforcement program today. Our current practices and capabilities are limited to collecting vehicle information. As such, we would need to assess points to the registered owner of the vehicle, who may not have been the driver at the time of the violation. To most fairly allow vehicle owners the ability to appeal the citation on the claim that they were not the driver at the time, DDOT would need to produce an image of the driver as part of the evidence package for adjudication. Collecting these images would require DDOT to have cameras facing both the front and the back of the vehicle at every relevant ATE location, one to capture the driver and one to capture the license plate. This would double the number of cameras required, as currently only 1 camera is deployed per location. Doubling the number of required cameras at each location would result in half as many speed and red light camera locations across the district. Given the demonstrated effectiveness of ATE cameras to reduce injury crashes and speeding, reducing the number of locations where cameras are deployed could have adverse impacts on traffic safety. Additionally, DDOT has not yet had the opportunity to test and verify the capabilities of our existing cameras to capture clear images of drivers, which would be essential for a points-based system. This bill also includes a requirement to publish unedited copies of traffic safety analysis worksheets, which are used by our team of expert engineers to recommend appropriate safety interventions, including the most effective placement of ATE cameras. We believe that shorter summary versions of these long and technical worksheets are more helpful and accessible to the public. This year, DDOT committed to providing worksheet summaries on our website, and we are currently building out a public-facing dashboard that will explain why each proposed ATE camera location was accepted or rejected. We are working to make this dashboard available this fiscal year, and we believe this will most effectively communicate the data contained in the worksheets. We would like to defer to our partner agencies regarding this bill's towing and immobilization requirements, but we do note that traffic control officers focus on ensuring pedestrian safety and do not currently carry the necessary equipment to identify boot and tow eligible vehicles. Our priority is to allow our TCOs and school crossing guards to focus on their primary responsibility, controlling the flow of traffic. Finally, regarding the STEER Amendment Act, we defer to our agency partners for any administrative implications that may arise from updating the definitions of reckless and aggravated reckless driving. However, DDOT requests clarity from Council about what specific rules it believes our agency should publish that are necessary to enforce the provision. To close my testimony, I'd like to reiterate DDOT's commitment to improving traffic safety and equity in the district. We look forward to collaborating with Council in achieving these and other Move DC goals. Thank you for the opportunity to testify today, and I am available to answer any questions you may have.
Thank you all very much. Appreciate that. I also want to note we've been joined by Councilmember Christina Henderson on the dais. And so, Councilmember Henderson, when we turn to you in questions, we'll certainly tack on a couple extra minutes if you'd like to make any opening statement. And let me also, again, thank all four of you for being here. Having the Deputy Mayor and 3 agency directors together to testify on this is no small thing. And so I just want to acknowledge that and appreciate it. And obviously, it speaks to the importance of 4 significant bills that impact each of you. I will say, though, I do just want to respond to what felt like a bit of a recurring theme in some of the testimony, though, which was a concern about how new functions assigned to an agency would strain existing resources and employees. Felt like focusing a lot on the things you can't do rather than the things we need to do or could do. I didn't really hear much in the way of creativity or ideas of how to make the changes we need to make things work better. Unless you're arguing today that everything's working just fine, which I don't think you would and isn't supported by any of the outcomes or experiences on our roadways, I'm just concerned about that overall theme. I want to commit to all of you. The council has asked, and I believe remains willing to work with you and to allocate better resources you need to do that work. It's why when we look at legislation, we look at a fiscal impact of a bill. It's why bills don't go into effect until they're fully funded. It means, for example, if Director Spriggs needs a new IT system for his team members, then let's work together to get that funded. So I just want to make sure you heard that commitment as we work on this together, that if there are barriers to implementation, I'd love to be able to focus on how we overcome that barrier, because change is what we got to create here. With my questions, with my first round, kind of turn right into one of the things that I guess kind of concerned me with some of the data that we got back, but also it was a major theme in some of our earlier oversight hearings on this topic earlier this year. So in the pre-hearing responses that we got back, it asked some questions around DUI enforcement. And I was struck by one of the responses talking about the Ignition Interlock program that individuals who've committed a DUI must enroll in. So 6 months for a first offense, 1 year for a second offense, 2 years for a third offense. So that program installs an ignition interlock device in a person's vehicle that can test their blood alcohol content before allowing them to turn that vehicle on. So in our pre-hearing responses, it indicated only 8 people are enrolled in that program. And that seems very low given the fact that the DMV was forwarded 326 convictions for DUIs in FY23 alone. And in the letter, it said that DMV has now identified 335 residents that are required to enroll in the program or in the process of contacting them. There's a lot of daylight between 8 and 335. That's not going to be a rounding error. So I wanted to ask specifically, have all 335 of those residents been contacted and notified? And I don't know if that should go to Director Robinson or to the Deputy Mayor.
Mr. Chairman, I'm going to turn to Director Robinson to answer this question, but I did want to just touch on your comments on the theme of this hearing. And I appreciate your comments, but I want you to know that the theme that we were trying to get across is that we we do appreciate the spirit of these bills, and we do look forward to working with the committees to ensure the safety of all district residents. Now, to your specific question, I will turn to Director Robinson to go over that.
Okay. Thank you, Deputy Mayor.
Thank you, Deputy Mayor, Council Member Allen. Yes, so you're correct that the number 8 is striking. Now, I will preface my statement to say that the mandatory piece of the Ignition Interlock is a new program for the District of Columbia where it's mandatory. It was a voluntary thing until last year. And so the 8 number is still a low number. Now, I will say that of the Ignition Interlock program, only DC residents are eligible for our Interlock program. But we know that most individuals that commit DUI offenses in the District of Columbia are not district residents. So when you see that number, then that number is indicative of that fact.
Robinson,
Yes.
I appreciate that. And I was definitely going to get to the distinction between DC resident and non-DC in a moment. But to the 335, that's DC residents, correct?
So those are DC residents, yes.
Okay. Have they all been contacted at this point?
They are all currently revoked and contacted. So yes.
Okay. When were they contacted about the fact that they were supposed to be in the Interlock program?
So they are told about the Interlock program at the time that they are stopped on the roadway. You are given notification. So the 3340 form that you ask questions about throughout the pre-hearing questions, individuals are notified on the roadway by the officer. So they're given that pending revocation notice on the roadway, and that is their first notification.
But who actually ensures that this is required, right? So who is it that would notify them that it's a requirement, not just the 3340 form?
Sure. So the 3340 notes that it is a requirement. Now, the thing is, the DC law is structured that your license remained revoked until you complete the program. So, of course, we need to do more as we're looking at this new program that we just started, the mandatory piece of it last year, that maybe there is more as we look at the spirit of what we're trying to do today, is to ensure.
Director, what I'm trying to get to is, when did we discover that 335 people needed to be notified and take action? The way that the response back was that the DMV has identified that there's this group, this very large group, and is in the process of contacting them. I need to understand what happened there. Was this just a recent discovery?
So we've been doing a lot of scrubbing and process improvement of our system in light of the incident that occurred earlier this year. And so we're doing a lot of review of our processes, of our systems, to make sure, as I think we mentioned in some of the questions that you asked in June, that we would be working with Superior Court, we will be getting data that we would need to go through, and that if indeed there's things and actions we need to take as a result of the information that we get, that the DMV will be committed to take action. So yes, part of that number that you're seeing is us taking action from our process review and working with our partners to ensure that we get everything in the system.
But when were they found? Were they found in June? Were they found last month? Were they found a couple of weeks ago? When was this large group found?
So it would be in between that period of time of us working from June until now.
When? I mean, I'm struggling to just understand.
So I think
you were finding a couple
so I didn't find
you were
all
doing a rolling scrub, or this was something that when we asked the question, that's when we found out that we have this.
This is a rolling scrub. So this is not necessarily we find all of them all at one time. And so what we're doing is, as we communicate with our partners at Superior Court, OAG, U.S. Attorney's Office, that we are taking those actions. But to your point, yes, many of these actions that you are referring to in the 300 were indeed recent, but it's a part of the greater process that we've been working on since June, when we understood that we needed to do a good fine-tooth comb of our entire process. And so,
but isn't would you agree the Interlock system is one that it is an effective tool, right? Like, it is a very effective tool to make sure that somebody who has a DUI and who has driven drunk cannot go back out and drive impaired again.
yes, I would agree.
Okay. So I'm struggling with where the urgency is to recognize that we've got 335 people that have fallen through the cracks is what it feels like. Not what it feels like, it is. Let's just call it what it is. 335 people fell through the cracks here. They're supposed to have an interlock device, correct?
They are required to get an interlock device before they can get their license back. So each of those individuals are currently revoked and should not be on the road. But I agree the interlock program is an effective tool because we know individuals continue to drive even after revocation. So I agree with you. And so we are taking those steps, as we mentioned that we would do in those responses we gave you back in June, that we would do the work and correct them as we find it. So you are correct.
And so when is the deadline? When should we expect that those 335 individuals would have an interlock device on their car? Is it next week? Is it mid-November? What's the deadline?
So I would imagine before the end of this year, this calendar year, that you would see an uptick in the number. Now, I will say that I can't force an individual to go and get the interlock program immediately, right? Some people will suffer the revocation for a duration of time, or just take the revocation and that's it. So I can't effectively install the thing, but I can tell them that you cannot receive your license back until you have effectively completed the program. So it is my assumption that based on what we just talked about, that we've done this fine-tooth comb, we have notified the individuals that we needed to go back and hit, that I'm pretty sure not all of those are going to say we would accept the revocation and remain indefinitely suspended until infinity. So I imagine they will.
I know my time is up on this round, so I got to turn back to my co-chair here. This is urgent. I mean, you got somebody who could go back out and we could have a Rock Creek crash and tragedy all over again. I feel like this has got to be a lot more urgent around 335 people that are identified, that we know. Not end of the year, it should be end of the month, end of the week. My time is up, so let me turn to my co-chair here. But Director Robinson, I'd like to work with you, help make sure you've got the tools you need, but we got to crack down on this a lot harder and a lot faster with a much greater sense of urgency. But let me turn to my co-chair now.
Do you want to answer?
I just wanted to respond. I have to be very clear. The Ignition Interlock program is a voluntary program in the sense that some people will accept their revocation.
Right.
And live with it and never get a license again, right? But in order to receive a DC license again, or to restore that privilege in DC as a DC resident, you will not have that option until you've completed the program. So the revocation in and of itself is a punitive action against the individual, and they should not drive.
But eight people with an interlock, 335 that do not. What's the number out of that 335 that just accept the revocation then? What's your experience been on that?
And that's what I mentioned in my earlier response to you, is that we do have a presumption that this number will increase now that we have taken the actions that we've taken after we said we would do the work that we did do. However, I must give individuals time, in order to get this installed, right? Meaning they have to make appointments, they have to get this device installed. Some of them may even have to come up with the funds to have it installed because it is not a free program. And so I do imagine that there will be some significant movement in this number before the end of this calendar year. So I agree with you, and it likely will be sooner than that because the individuals, that are trying to do the right thing, maybe not all of them, but some that are trying to do the right thing will indeed take the steps to move towards getting their license back, which will require the Interlock program.
Yeah, it's just the fact that we have that many that slipped through the cracks and fell through the cracks puts people at risk every single day, and that's the urgency we've got to have to go after that. I appreciate the responses, and I know I'm over time, so let me turn to my co-chair, Doc.
It's cool. We just stopped the clock for you, so you don't know. You'll never know how far over time. Okay. I think this is for the deputy mayor, but feel free to jump in, anyone. So this year, you started a program to send communications to dangerous drivers to try and change behavior. Can you talk about that program and whether you think it's effective?
That is correct, Madam Chair. The Vision Zero team did work with the lab to identify drivers that are high risk, so to speak, given their driving behaviors and the citations they've received through ATE. Those drivers were notified over the summer about their behaviors and the effect their behavior may have in crashes. And so hopefully that education piece will deter speeding. But we are still researching the effects of that communication with those drivers.
How does that program distinguish between different types of violators? Do you think that framework could be helpful for some of this legislation?
I don't have the exact algorithm in front of me, but I do know it's based on the amount of ATE tickets that someone has received in a certain time period, making them a high-risk driver. A lot of drivers don't realize that they're high risk. And so we want to make sure we educate drivers that, speed does have consequences, and there's a reason for speed limits. So it's based on the amount of citations that you receive, and we'll be happy to work with the committee as we move forward with this.
And those go to all drivers that qualify in any state?
Yes, it does. That hit a certain threshold of tickets.
Okay.
Thank you.
New topic, license plate readers. All right. According to the pre-hearing questions, we currently have license plate readers on 34 MPD vehicles and 30 fixed poles. Are the fixed pole LPRs also MPD devices?
I believe so, Madam Chair, but we'll verify that.
How many are actually operational? Because I get complaints from MPD about the vehicle license plate readers being broken and out of service.
I would have to check with the Deputy Mayor for Public Safety on how many of those are operable.
Okay, so do MPD's readers only look for stolen vehicles and wanted persons?
It is my belief that that is what they look for at this time.
So not scofflaws the way DPW does?
Correct.
How many LPRs does DPW parking enforcement currently have?
LPRs?
Yeah.
Twenty LPR vehicles that we currently have.
Are they all operational?
Yes, ma'am.
How many new devices do you expect to have within this year?
60. We're looking at 60 more devices to come in.
Those are the ones that were held up at DDOT?
Yes, ma'am.
Can DPW's readers also flag stolen vehicles and send that information to MPD?
Yes.
All right. So I did a ride along with Department for Hire Vehicles, VIOs, the other week, their vehicle inspection officers. They also have LPRs, I think, on all sides of their vehicles. But of course, they only flag registered for hire vehicles. So we were told that the other info picked up by their readers supposedly goes to other relevant agencies, but at this point, I'm not confident that's actually happening. Can anyone at DPW confirm whether for hire vehicles, license plate readers communicate with you?
We do, currently, ma'am, we do not get vehicles for hire data.
Okay, so we're identifying some gaps here. Deputy Mayor, in pre-hearing questions, you responded that MPD does not have direct access to DPW's system and that if they wanted to find that information, an MPD officer would need to use the same online portal the public does. Is there any legitimate reason that's the case, or do we just not have the right databases speaking to each other to make that possible?
That is correct, Madam Chair, and currently we do not have the databases to make that possible, but I do know that's something that DPW has looked into, and I'll turn to Director Spriggs if there's any more on that.
Are we making reference to looking at more LPRs, the actual integration? Because there are some things that I can communicate that we do have with DMV. However, there's limited to none with MPD. The only system that we have in common is the well system.
And when is that utilized?
That is utilized by a secure member of personnel at DPW that actually goes into a deeper detail about the offense or something else or other priors pertaining to the individual vehicle.
And what normally instigates that?
What normally instigates that is that when there is an offense that we look at the vehicle, we're able to contact the well system. The well system does a deeper dive in that with the well system and lets us know if perhaps that the vehicle has been stolen, then therefore it is a notification to MPD to help take care of that.
Does that happen with every vehicle that comes into DPW's possessions or system?
For tow.
Or tow?
Tows, yes.
Every tow?
Yes, ma'am.
But what about with ticketing? With ticketing, just towing, because that's one
Just
that you
towing,
have
yeah.
on site then.
Just towing.
So that's what I saw when I visited at Bryant, where you're there with the tablet looking at the vehicle?
Yes, ma'am.
Okay, and only certain personnel are trained on, it's called whales?
Yes, ma'am. There's
Okay.
only finite personnel. There's a different level of use the word security requirements and an extra deep dive into the personnel background to make sure that they do not give out said information to people. Yes, ma'am.
So how often does it occur that DPW comes across a vehicle that is in that system and MPD needs to take action on it?
At this time, I do not have the data in front of me. I have no idea, but I will get back to you with that.
Okay. Hopefully it's clear. I'm trying to figure out how do we build on the tools that we have here to get at some of these issues. And it is challenging because these systems are not communicating with each other. And I think we can have a conversation about the security clearance and when it's appropriate for more people to have that or not. But in lieu of that, just how these things are being communicated, I think is something we need to keep talking about.
If I may say,
Sure.
I would like to stay away from the word security clearance
Okay.
and use the word, it's a higher degree of background investigation of the individual instead of the word security clearance, because that's a different, we're going down a different avenue with that, so.
Understood. Thank you
Yes.
for that clarification. Okay, that appears to be my time for this round, but I will be back with you all. Chairman, I think it's over to Councilmember Fruman.
Yes, I can't see if Councilor Fruman is still here, but I think he is next in the lineup.
I am still here. Thank you very much. I'm just going to have maybe a few big picture questions. I thought that the data on the percentage of vehicles that are in violation, that it's 1%, 99% of the cars that pass the traffic cameras are in compliance and 1% is not in compliance. And is that right, Acting Director Kirschbaum?
Correct. For speed cameras, 99%, it's probably 99.1% of the vehicles that pass over through the camera do not get a violation, but 0.9% of the drivers that are going through do.
So then over a 3-year period, as Chairman Allen said, there were 3.5 million, 3.7 million, we'll call it 4 million, just to 4 million violations. And so 400 million, there were 400 million passes, but 4 million violations. Is that right?
So I just wanted to clarify, and the council member clarified that as well. That was over a 3-year period, so it's closer to 1.3 million on an annual basis.
So and then 1 million, so then there's like 130 million passes on an annual basis. So, but 1.3 million is still a big number. And to what extent you guys did the high-risk letters? How many people did you send those letters to? What's that universe look like?
I'm actually not sure of the total number that received the letter through the study, the lab assessment. And I should say, too, they're not trying to get to 100%. I think they want to have a control group to compare it to see the impact. I don't know if anyone here knows the actual total number that received the letter.
Councilmember, we'll have to get you the actual amount of letters that went out, but Director Kirschbaum is right in terms of the intent and what we were trying to achieve.
And have you provided before a breakdown by jurisdiction and number of those letters? I think it would be useful to see who's in that group? What's the makeup of that group? How much of that group is in the district? How much of that group is outside of the district? Are there places in the district where the densities are higher or lower? Have you generated that sort of data?
We have not, but we'll be happy to look into that with you, Councilmember.
Because I think one of the things in the public safety world, yesterday we had a big hearing on public safety, and there was a lot of emphasis on there's a small group of people that could be the source of a lot of the violence in the city. And it may be that there's a relatively small group of people who are the source of a lot of the traffic danger in the city. And if that's the case, what all of these bills are trying to get at is how do we reach those people and have an impact on their behavior? And I heard, and I guess I'll pick up on Chairman Allen's reaction, was a lot of things being said about why things couldn't be done. But there is a problem, and we need to figure out how to address it. And so I'm curious to hear what kinds of things, as you have all been looking at this, would you like to see be done to strengthen the regime so that we can make our streets safer? Because we haven't gotten there yet. Or do you think that the things that you're doing, it's just a matter of time, and if we stay on that path, things will be better?
Agreed. And just a quick update, Councilmember. There were about 100,000 letters that were sent to drivers and in the District of Columbia and other states. There were 30,000 letters that were sent, my apologies, that were sent to drivers that alerted them about their behaviors. So we'll continue to monitor that. I think you made some good suggestions in terms of what to look for, and I'll make sure we work with the team at the lab and deed out on that. And Sharon, was there any more that you wanted to add?
No, I do want to just underscore that we do need to have a full frontal assault on this from every possible angle, and that there is no silver bullet. I do want to say that the program, the ATE program, is working. And I want to make sure that if we're adding new tools in the toolkit, that we're trying to get to those individuals that we're not able to get with the programs that are working. So I know we had said 1% of the drivers going through speed cameras are getting tickets. It's a little lower than that. 70% of the people passing through our ATE cameras get one citation. That to me is very meaningful. It means that people are learning. People who want to be compliant, they get caught once and they modify their behavior. That is success. The speeds continually reduce. We look along the Anacostia Freeway, 5% of drivers traveled more than 11 miles per hour above the speed limit before the cameras. 1 month after the cameras were installed, that percentage has decreased to 2.2% and decreased extreme speeding by more than 50%. And we continue to see this improved compliance over time. There is always a small subset that will not be impacted by a ticket. They're not changing their behavior, and we need to be creative. And that's why the lab is trying to take a stab at some of those folks. There are other strategies that are needed, but I just want to make sure that we're not tweaking or doubling down on the programs that are working that aren't getting to the folks that these miss.
No, I hear you on that. And I mean, there's going to be a pretty substantial expansion of the number of traffic cameras out there, and hopefully that will help. But it's the exact thing that you're talking about. I mean, that it may be that a lot of the behavior is improving, but the traffic fatalities are not. And so something's not, all the dots are not being connected. And it seems like you recognize that, and everyone is groping for what is the way that you can get at this. And we haven't figured it out. And in the government testimony today, I share the reaction of Chairman Allen. I heard an awful lot of, we can't do this, we can't do that. And it may be true. This isn't, that some of the solutions that have been proposed, maybe they do pose practical challenges, but what are the things that we can work together in order to get at this? Because I can't imagine that anybody on the panel is satisfied with where things are at. One last kind of combination of questions as opposed to just a comment. And one of the things that I heard was capacity on towing, capacity on lots for parking vehicles that have been towed. What do the economics look like in the money invested in towing and booting? Does that end up leading to a higher return than the cost, or does that end up being cost negative? That is to say, if we proposed additions to the capacity for those things, if you looked at a fiscal impact, would you expect that fiscal impact to be positive or negative?
Sir, I have not, this is Tim Spriggs, DPW, I have not looked into the overall cost, but I would like to take this opportunity to comment on one of the issues that you made, and that was that I think it's important to understand that we are moving forward here at DTAP. You brought up the point about the additional lot. We do have 2 current lots that we do have, and we're in the process of, we're looking at getting another 3rd lot, because currently I only have enough space for 1,092 vehicles on 2 lots that we currently have. Also, sir, we're also bringing on additional PEOs, patrol officers, and MVOs, so that we could do more towing and more booting, and then so that we can do to increase our posture, some of the things in which we're doing to move forward in support of the actual ATE. So to say, could we do more? I'm sure that we can, but to say that we are complacent or not moving forward as steady as other people would like, I would just like to iterate now that we are within the space and limitations that we do have, because our 2nd lot just opened up, and within, let's say within the 1st month, we're almost at capacity. So we do, along with the additional booting and toting that we are doing, we believe that not there yet, room for improvement, but we are moving forward.
So I have to say, I'm well over time, and I'll stop. But I mean, I'm very glad to hear that. And actually, in the testimony, when you talked about limited capacity, I think I would have been comforted to hear you. Yes, we have limited capacity, but we're trying to expand that capacity, and please support us in doing that, because we would want to support you in doing that. Thank you very much.
Thanks, Councilor Freeman. Let's turn to Councilor Henderson. I believe she's still with us on the dais.
Yes, thank you, Chairman Allen, and good morning to all of you. Thank you so much for being here. And I want to start by saying also thank you for the work that you all are doing, as well as the works of your staff. I see the TCOs out on the street. I see the boot and tow crews either putting something on or standing there with somebody who is waiting to get it off. I've emailed with you, Director Kirschbaum, about placements and things like that where we feel like we need additional infrastructure because a camera is just not doing it. And Director Robinson, you and I have had plenty of conversations about some of the work in terms of DMV. So I appreciate the work that is happening, and I want to start there. I do want to follow up on some things that you all brought up in your testimony, in particular around some of these bills. And I know this is kind of one of those weird situations where perhaps it wasn't, when you're testifying in this way, it doesn't allow for opportunities for collaboration or recommendations, because similar to Councilmember Freeman and Councilmember Allen, as I'm listening to you guys testify about, oh, this is a challenge, I didn't really hear, okay, but if you tweak this or do this, and perhaps this isn't the environment for that. But through questions, I hope that we can get to some type of piece there. Director Kirschbaum, and I'm just gonna call you director. I know you're acting, interim, whatever it is, but we're just going to go with the easiest frame because you worked at DDOT for a long time. So you talked about the study that was commissioned in 2021, and I believe 29 locations were picked at the time. Are you all comfortable with that sample size, given that we have, over 150 cameras deployed at this particular juncture?
Sure, and I should say the 2-year data, I think it was 2017 and 2018. So This was a while back. We didn't have the full complement, but we do want to continue to assess, and we believe that, yes, looking at this, we now have, that was speed cameras only, we have red light cameras.
Right.
We've got many others, so we'll continue to look at the impact of the new complement.
Okay, so it seems though that you all are using this study to sort of say the ATE camera program is effective. Is that the view, that we're good, we don't need any changes?
The point I'm making about ATE cameras is that it is changing driver behavior. Okay. Is it 100% effective? No. Okay. But I wanted to make sure that when we're looking at tweaks to the program, I would say let's roll out our 744 new cameras. Let's get the new cameras installed. Let's assess what the impact is, and then make determinations of what needs to get tweaked. But right now, we're seeing really good response. It's never a one-fix silver bullet.
Oh, sure. Okay. There's always a bad driver out there who thinks that they're above the law, or their one time of rolling through a stop sign is not going to hurt someone, and in fact, you've injured a child, right? So I totally understand that. I'm just trying to sort of get the feelings, because I know that, the Committee on, at least Transportation and Environment, which I've been on for longer, we've been talking about this for a while. And I know that there's been a working group who's been looking at some things and talking about some things. And so I'm just trying to get us beyond just talking into some sort of action, which is sort of the reason why I ended up introducing the bills that I did, let me then offer up a suggestion on perhaps how we can sort of improve. Deputy Mayor Anderson, you mentioned in your testimony, for the small group of drivers who are not deterred by ATE cameras, DMV can suspend or revoke an individual's driver's license upon, in accordance with district law. How? Because my understanding in conversations with Director Robinson is that unless an MPD officer is pulling that person over, we really have very limited tools in terms of how we can go further.
Yes, Councilmember, return to Director Robinson for the answer.
Thank you, Deputy Mayor. Yes, your understanding, Councilmember, is correct. DMV does not have the authority currently to suspend or revoke a license based on ATE tickets. Some of the bills before us today would give DMV that authority to assess points on ATE tickets to the owner of the vehicle, not knowing if they were driving or not. It would assess points to the owner of the vehicle. I did caution in my testimony, however, that would only impact DC registered owners, right?
And I can acknowledge, I feel like it is incredibly frustrating that we're sort of dealing with this issue of traffic violence and traffic safety with one hand tied behind our back, because we don't necessarily have cooperation from our neighboring jurisdictions on sort of dealing with some of these things. And which is kind of wild when I think about it, right? I think my first and only speeding ticket where I was like pulled over by someone, I was in one of those backwood towns in North Carolina, where if you're going like 15 over, it's an automatic court appearance when you're pulled over. And not only do you have to appear, or you have to hire one of their lawyers to handle your ticket, but we do it because in the spirit of the compact, and I don't feel like we have the spirit of the compact going on here.
Well, I do want to speak on that briefly,
Okay.
right? Because I know many of the leaders of DMVs throughout the country, and all of those are professional individuals that are committed to traffic safety as we are here. The issue that we have with the compact when it comes to ATE tickets is that we have not positively identified the driver.
Okay.
Right? We identified the car. We positively identified the car, which is why we currently assess fees and fines to the owner of the car because they're responsible for their vehicle.
Right.
But when we start talking about traffic behavior and your behavior behind the wheel, we really need to pinpoint the driver. And so those leaders in other states will have leery about assessing a point.
But don't I have some responsibility as the owner of the vehicle of what activity is happening in the vehicle that I own?
You do, and that's why we currently assess a fine to that owner of the vehicle. And as you know, we have learned is that most people comply when they get that first ATE ticket, or they comply when they realize the camera is there. So owners, some owners are saying, hey, I got an ATE ticket,
Okay.
We're not getting that, right?
Okay, so let's say I accept and acknowledge the fact in terms of we don't necessarily have the infrastructure now. Director Kirschbaum, you talked about we are about to deploy X hundred new cameras. How many of those are front-facing that we've ordered?
Oh, the 447 new cameras, we don't have any that are front-facing. They're all designed to capture the license plate.
Don't we have license? Well, Virginia. Okay.
And keep in mind, even if there was a front camera that was trying to capture the license plate on the front, it wouldn't be able to get the driver as well. It has to be more targeted. So you're either trying to get an image through a windshield of a driver, or you're targeting a license plate.
Okay. Have you all had any conversations with other jurisdictions who do this? There is one in Arizona who provides points on ATE.
So
how are they doing this?
So we're aware of two jurisdictions, and I'll tell you, California and Los Angeles County in particular actually had front-facing cameras to take images of the driver. They have shut the program down. They found that 40% of the images were blurry and had to get thrown out. There was a proliferation of drivers who were wearing masks of presidents and other people. I mean, people sort of caught on that, a well-placed mask or obscuring your face was a good way to get out of this, because the onus was to prove that this driver was actually the one driving the vehicle at the time.
Okay.
And so losing that percentage of images, I think, really diminishes the impact of the program. We have to make sure we have a very clear image of a license plate now, and we still have about 4% that get washed out. That's even after the contractor reviews them, and I think they lose about 7% because the images aren't clear. So
if the image is not clear, that means the person is going too fast?
Well, it could be for any number of reasons. The license plate could be obstructed because there's a car going in the other direction. It could be because there's a deliberate obstruction of the tag. It could be because it's just blurry. There's a number, it could be a sun glare, it could be any number of reasons why.
Okay, I'm over my time. I have more questions. Councilmember Allen?
Great. All right. Thank you very much, Councilmember. Let me jump in with another round. But actually, first, let me ask Councilmember Nadeau, because I know you have something to share at 1 o'clock. Did you want to do a little bit longer time for rounds to make sure we've got time for your questions?
That would probably be helpful. Maybe we can sort of see how it goes with this round. Would that be okay?
Absolutely, of course.
Thank you, sir.
And if we need to come back around or add extra time, just let me know.
Thanks.
So I'm going to kind of jump in with the ATE conversation as well. One of the data points that at least jumped out to me when reviewing those pre-hearing responses is simply the massive number of citations issued by the ATE system compared to the comparatively scant number issued by MPD and other law enforcement officers during in-person traffic stops. So for speeding 11 to 15 miles per hour over the posted speed limit, the ATE system issued 2.9 million tickets compared to just 2,983 tickets in person over the previous 3 years. For speeding 15 to 20 miles per hour over the speed limit, ATE captured 576,000 tickets compared to about 4,800 tickets in person. So what that tells me is that 99% of all moving violations in the District of Columbia are detected by our ATE system. Only 1% are detected by traffic enforcement officials. So I don't doubt, for example, Director Kirschbaum, as you talk about the metrics you're seeing of when a ATE is deployed and then behavior changes that you're seeing there. But, I think, Director Robinson, you'd raised the point, I think, in your testimony that in what way would, when points are assessed or the consequences thereof, in some way be altered by one of the proposals here. But if points can only be assessed by in-person traffic enforcement, and that only represents 1% of the violations that we see, what are the ramifications of that pretty stark division of responsibility between camera enforcement and traffic stops that the city has decided to take? Continuing to talk about how we're going to use our point system for an exceedingly small slice, only 1% of those infractions, feels like that system has not caught up with the policy choices the district has made to switch to a essentially all ATE traffic enforcement system. So I guess, Deputy Mayor, I'll ask you and maybe Director Robinson on that, and I'll follow up with another question.
Mr. Chairman, I'm going to defer to Director Robinson.
Thank you. Thank you. You're correct, Councilmember Allen. The DMV, in order for us to do the work that we would need to do to remove a driver off the road for consistent bad behavior for speeding, we need to know who the driver is. And so I think there needs to be a greater conversation about, as you suggested, balancing the ATE operation with having those personal service tickets issued by Metropolitan Police Department or one of the other 27 other agencies that issue personal service tickets, like Park Police, Capitol Police. All of these agencies can issue personal service tickets, but they don't issue it nearly as many as the ATE system. So I do believe there is a greater conversation and something to take away from this hearing as something that could potentially have a faster impact, because DMV already has the infrastructure to assess points, even with reciprocal actions from out-of-state, entities and DMVs. If we stop that individual on the roadside and ID them in the vehicle and issue a ticket. And so maybe there is a conversation, in my opinion, about a balance between those personal service tickets and ATE.
Okay, and I appreciate that, Director, but I don't think there's any balance left, right? Like, I think we need to go ahead and just acknowledge that if 99% of the citations being issued are automated traffic enforcement, there's no really balance there to be gained. We are essentially and effectively a 99%, almost 100% there, right? So if that is our system, and we heard DDOT talk about the additional cameras that have been ordered that are going to be deployed. So that policy choice, that's past us. That's what we got. So I recognize that. And I can recognize what are some of the concerns around using that ATE system if we're going to talk about assessing points. So you would say, again, the capabilities are limited to collecting vehicle information in your testimony. in that without the photo of a driver, you would need to assess points to the registered owner of the vehicle who may not have been the driver at the time. And then when we talk about non-DC residents, DDOT would need to, you're saying first DDOT would have to produce an image of the driver as part of the evidence package for adjudication, but I want to, I guess, push back a little bit based on how we identify the vehicle or vehicle owner. Currently, we issue tickets based on ATE cameras, even though we don't capture that driver's image. And then those fines and tickets are issued to the vehicle owner, even though we actually don't know whether or not they were driving. So when's the last time, for example, the DMV, our DMV, asked for a list of, an address of vehicles in Maryland?
So when an ATE ticket is issued, then DMV, in our current process, goes out and get the vehicle owner's information, right? So I do get the name of the owner, I get the address of the owner. I do not get a driver's license number. So in order to assess a point, I need a driver's license number for an individual. The only group of individuals I have a driver's license number for is a DC resident. So assuming that this bill passes, I can issue points to the owner of a vehicle in DC. So DC residents will feel the brunt of it immediately. I would not be able to do that for out-of-state because I do know who the owner is. I do know the address. So your question asked me about the address. I have that. I have the name. I don't have a driver's license number because I don't need it for the current system because we can only assess a fine to the registered owner.
But I guess, so to follow that thread a little bit, so let's say a vehicle is used in committing a crime, and the Metropolitan Police Department is looking to identify, based off a license plate of, let's say it's a vehicle with a Maryland or Virginia or North Carolina tag. Let's not just pick on Maryland or Virginia. And MPD would want to get the name of that driver very quickly. I feel pretty confident MPD's got a system set up where they'd be able to get that name, be able to get that information. Why wouldn't the states be able to provide the same information for a traffic violation to you in a way that allows us to move forward with our other tools of immobilization?
So I'm able to get a name of the owner. MPD would be able to get the name of an owner if the only thing they have is a tag number. But if the owner isn't driving the car, MPD will have a lot more work to do to determine who was driving the car and then to identify that person. That's the same work I would have to do at the DMV. I get the name of the owner of the car, but that's not sufficient in order to do what the bill proposes I'm supposed to do for an out-of-state resident. So it's bigger than just knowing the name. I need more information, particularly for one of my counterparts in a neighboring jurisdiction to give me a driver's license number because DMV will not release PII information if we don't have sufficient cause to need it. In the case of an ATE ticket where we do not know who the driver is, then a driver's license number is not necessary in order for me to impose a fine to the owner of the vehicle.
Okay, I know I'm out of time, but I guess if we know that ATE is 99% of our system, so that's pretty close to 100, then we've got to have the ability to work with our other states, and we know the tag number, we know the names now. We have tools in the toolbox to be able to assess where we need to, as well as then help identify and then immobilize that vehicle as well. And that's what the legislation package of bills I think are really aimed at is how is it we're getting at the relatively, as you said, DDOT Director, that a lot of people are, they pay that citation and you don't see them get a repeat citation. But we got a significant chunk that do not follow that rubric. And that's what we're trying to go after. I don't think we want to just keep studying this at the lab. We have a package of bills that are trying to go after these dangerous drivers because the ATE system that might work for you or me isn't working for this other group, and it puts folks at danger on our streets. And we want to have the tools in there to be able to equip you to be able to take those actions. So I appreciate this round. I'll come back on another round. Thank you. And let me turn to Councilor Nadeau.
Thank you, Councilmember Allen. All right, Director Spriggs, we've discussed in the past how parking enforcement officers can only see the dollar amount owed on a tag, but not what the infractions are or whether the vehicle's boot or tow eligible. Is that still the case? And if so, why is the system that way?
It's still the case. We wanted to focus on the violation that they actually, that they actually discover. Stay focused on the violation, not the individual.
Why?
Because I do not want to start to get into the area of targeted, started that area. I just want to focus on what is the violation, focus on the violation.
But what if, so they don't know when they look at it if it's boot or tow eligible?
They would look at it as boot or tow eligible, but the goal is here, Councilwoman, is to stay neutral. And that's the goal in which I'm looking for. I'm not looking for them to start getting into the area of targeting certain things or looking for certain things. Go by what they're trained to do and look at that as a parking violation.
Why do you think the additional information would create a bias or a targeting situation? I mean, I guess I want to understand why that's a priority as opposed to making sure that we have enough info to find the scofflaws.
I think that currently with the information that they currently receive, that we have enough to determine what is a scofflaw. I think there's ample enough information in there because that gives us the opportunity to boot and to tow. What people are focusing on, as I indicated earlier, we only have 1,092 spaces available. We are moving them off the street. We are, after they've been there for 24 hours, we boot, we tow. And then after that phase, if they're there for 28 days, and that gives us the opportunity to actually auction the vehicles or use it for scrap. So we're trying to get them off the street as quickly as we can.
Okay, and the dollar amount, I mean, they will know if it's boot or tow eligible, but they won't know if it's a moving violation or whatnot, and that's the separation you're trying to create. But that also, I think, contributes to the siloing we've been talking about earlier, where if one of the goals of the government is to get dangerous vehicles off the street, then shouldn't we have all of our people capable of assisting with that?
I would like to say that the DPW is open to see how we can integrate systems, to see, to take a look at that, increase the manpower that it does, and to leverage technology as we can. But
Okay.
I would also bring up the point, ma'am, that we must take a look at, the contract thing with our union employees and things of this nature too. So it's something that we could collectively discuss. Is DPW close to it? Not at all. But it's worthy of a table of discussion to take a holistic view.
Okay. Does DPW immobilize and tow vehicles that have 2 or more in-person moving violations, or is it only for camera and parking tickets?
It's for cameras violations, and towing violations.
Is that because you're not authorized to do more, or because you don't have access to that information?
The primary reason is the actual access to the information.
But there's a secondary reason?
No.
Okay. Okay, I'm hearing you, and I think we need to keep working on how we're getting at this Vision Zero goal with the tools you have, so we'll keep that conversation going.
Yes, ma'am.
All right, to our colleagues here at DDOT and DMV, does the information we were provided on in-person moving violations include those issued by DDOT traffic control officers?
Right, I was going to say DDOT traffic control officers do not issue moving violations, so I'm going to say no.
Okay. That answers my next question, so thank you for being efficient. Okay, so I do want to move into the Fraudulent Vehicle Enforcement Amendment Act. And Director Spriggs, you mentioned in testimony that a prohibition on covering vehicle plates with plastic or other materials is already in regulation. Is that something that's currently being enforced?
Yes, it is.
Okay. Now, is that a separate category of infraction or just a failure to display?
Failure to display.
Okay. And your officers have the ability to lift up the plastic and check all of the information?
We're trained. They often do that, but they're not trained to do that. And what I would recommend is just that if we could find, if individuals choose to use covers, that there are covers that are designed that could still show the actual license plate, although that there is a cover over their vehicle.
Right. Should they be trained to do that?
The idea of having your people trained is one thing, but safety is another issue.
Yep.
Because that is personal property. If somebody lifts up the cover sometimes, some people might say, one, hey, you're interfering with my property. Two, they can come back and say it's damage to the vehicle. So in order to be consistent, it is not something that we're training our folks to do.
But it's a little bit of a catch-22.
It's, yes, ma'am, it is.
Okay. Now, for the ATEs, for DDOT, do the semi-opaque plastic covers on license plates create challenges for ATEs being able to issue tickets?
Yes.
Okay. Look, I don't need a long answer. Okay. So, all right. We did that. Okay. And Director Spriggs, from your testimony, you note that any vehicle with a tag that can be clearly identified as counterfeit, altered, or otherwise fraudulent by visual inspection alone would be cited for the violation of failure to display current tags. Now, I know we've had to work with you. We've worked with you on some of the more egregious examples of that, thanks to the team. But shouldn't there be some kind of standard for what you can say is identifiable by visual inspection alone, and then we can train our parking enforcement officers on that?
I think that that's something that we could work on collectively, legislatively, as well as to help us in order to train our people better. No reason to be opposed to that, but I just want it to be a standard process that both legally and that we can both do it operationally.
Okay. I think we want the same. Do you think there should be a distinction between a failure to display current tags, which could imply some level of accidental noncompliance, and a clear intent to present a counterfeit tag?
No, ma'am.
Because you don't think you can enforce it?
Yes, ma'am.
I knew you were going to say that.
Ma'am?
I knew you were going to say that. Okay, I think there's also a data issue here. All right, so failure to display tags could be an expired temporary tag, expired permanent tag, a counterfeit tag, or a missing tag entirely. And I think for both you and the council, it'd be helpful to know the breakdown of each of those. But I also don't think that's possible if they all get the same infraction. Are you able to break that out, or would you need new authority to distinguish between those different offenses?
I would require additional authority in order to break down the distinction, ma'am.
Okay. All right, Deputy Mayor, given MPD's resources and priorities, we don't seem to have a good way to confirm legitimate tags by verifying VINs, given that it requires a traffic stop. Should we have some dedicated staffing resources to focus on this? It doesn't necessarily need to be MPD, but it would need to be law enforcement with the authority to make stops.
I understand where you're going with this, Madam Chair. Let me have an opportunity to speak with my counterparts and dig into the matter
Sure.
a bit. I have not had that opportunity to do so, but we'll be happy to do so and follow up with the committee.
Okay. Yeah, and really just establishing that baseline of identification. I understand it's important. We've talked about that a lot today. I'm just not sure that it needs to be something MPD is doing, and thinking about all the other enforcement resources we have is really important here.
Absolutely.
Department for Hire Vehicles officers are an interesting example of someone with authority to make traffic stops, but with a very targeted focus, which I think makes them very effective. And there's been a lot of conversation about moving all traffic enforcement out of MPD, but I wonder if it makes sense to start small instead of trying to do that all at once. So if we could think that through a little bit, I think we could get somewhere on that.
Happy to do so.
Great. Director Spriggs, I believe PEMA is the parking enforcement management entity at DPW, is in the process of procuring new software for its enforcement system this fiscal year. Is that right?
That is correct.
Okay, what do you hope you'll be able to do with the new software that you can't do now?
One is to give us increased more on-time data, much more accurate data, and the ability that, when possible, to actually integrate with other systems. And that was the whole purpose of looking at this new contract now.
Will it be able to better communicate with other agency systems?
I do believe that we currently have the ability to do with some, but we could look at the integration of it and looking at the statement of work on what you plan to put out.
Okay. Yeah. I think better interoperability is really important to what we're trying to get at here. Is DPW's dispatch able to make judgment calls on where to send a tow crew? For example, if they get a simultaneous flag from PEOs, one for a vehicle with 2 unpaid parking tickets and one for 6 or 7 unpaid moving violations?
It's dispatching and goes down to the gentleman on the ground with the supervisors to ensure that that is taken care of. Yes, ma'am.
So would they, on the spot, be able to prioritize one or the other? Or would they be trained to do that?
We'll just dispatch the vehicles to both of the incidents, you know.
Okay.
But once again, we try to stay out of the priority.
If you weren't staying out of it, do you have the actual information to make those judgment calls?
We do not.
Okay. Okay. So I'm going to wrap and just, this is not a, well, there is a question at the end. There's a question mark at the end of this, but there's going to be a lot of talking before I get to it. So I'm just going to say that I think what both committees are arguing here is that we really need connection of all the systems, and I hope we can work with you all to understand what resources that would take. Parking enforcement officers may be coming across vehicles with loads of moving violations and wouldn't know it. An MPD may be pulling over people with $15,000 in parking tickets and wouldn't know it. We have license plate readers pinging plates all day, every day, but as far as I can tell, they're not speaking to each other or informing all of the agencies that could use that information, and those LPRs are expensive, and I think we should be getting the most for our money where we can on that. So I think this is mainly for the deputy mayor. Can we work with your team to understand what it would take to integrate these systems and what the associated IT costs would be?
I'd be happy to work with you in the committee on that, Madam Chair.
Sounds great. Thank you all very much. Thank you, Chairman. I think we still have Councilmember Henderson here for her round.
Excellent. Thank you. And that was a very succinct answer from the Deputy Mayor. I loved it. Thank you, Deputy Mayor. Councilmember Henderson, let me turn to you.
I guess I can't see whether or not Councilmember Freeman was there, so I wasn't necessarily.
Oh, sorry. I think that Councilmember Freeman stepped away.
Okay.
We return to you.
Okay, great. I'm going to get into a couple of questions, but I want to give perhaps an opportunity to clear some stuff up. Okay, so Director Robinson, in the pre-hearing responses, we asked how many records for DUI convictions that DMV received for FY21, 22, 23. For FY23, you say 494, obviously amongst various jurisdictions, et cetera. The next question was how many times did the agency revoke or suspend licenses for drivers related to those things? And for FY23, the answer is 0. Was that a typo?
So that's not a typo. So the question for question 4 is talking about the number of licenses that we have revoked for individuals pursuant to a certain code where they've had 3 or more DUIs in the last 3 years.
Okay.
So they have a different suspension because they're indefinitely suspended for at least 5 years.
Okay.
So that question speaks to a specific code, and it's to the code about indefinite suspension after 3 violations for drinking and driving within a certain period of time.
Okay. In terms of the number for FY23, I know in a previous hearing you talked about the agency going through a particular audit process in terms of changing processes and procedures with Superior Court to make sure you have the updated info. How confident are you that the 494 number is accurate?
I'm confident because that number is from our work that we've been doing over the time period that we've been going through the scrub.
Okay.
So I'm confident.
Okay. I want to ask a couple of questions in terms of fake tags. Director Spriggs, you mentioned that your folks can't necessarily tell a fraudulent tag from a not fraudulent tag, but some of the fraudulent tags that I've seen, like, they're not even trying. Like, they're not even using cardstock. They're using regular schmegular paper. And so when we see those, like, truly egregious, you didn't even try, what happens? Okay.
I mean, if it's egregious and very obvious,
Okay.
then failure to display.
Okay. So can you just talk to me through the process a little bit? Because the National Insurance Crime Bureau testified at the public portion for this hearing that, quote, criminals are using long expired or outright counterfeit tags to create ghost cars, which are then used to facilitate other crimes, end of quote. So if violent crimes are sort of begetting some reckless driving, isn't everyone safer if we had a tighter policy that it's not just if DPW sees it, you note it in the system or you give them a ticket, but rather someone is alerted that this vehicle exists, because it could be a vehicle that MPD is looking for that you have found, but nobody knows.
If it's, there needs to be a better way to communicate between us and DPW. And I do know that sometimes within the license plate reader, that is an indicator, and therefore we notify MPD that we have found a said stolen vehicle because it's already in the system. That is a joint system between us and MPD.
Okay. So the system can tell you if the car is stolen.
Yes.
What else can it tell you? Of things from MPD, or is that the only thing from MPD?
That is the main thing, and we just informed.
Okay. So then I guess that's a question for MPD of who is alerted when you all flag it, and then what is the follow-up that happens thereafter? Okay. I want to switch to talking about the license suspension reform bill. Director Robinson, I hear you on your testimony where you talk about the need for due process. I'm not a lawyer, but I can appreciate that part of our Constitution in terms of the need for due process. However, the way that we crafted the legislation, I felt like we pulled out some pretty egregious things, whereas you were involved in an accident that killed someone, or you were involved in an accident where someone was physically injured and you left the scene. I understand the need for due process, but I also struggle with what then do I say to the families that, yes, this person has been charged, but they can continue to drive until their case is adjudicated.
So due process is a real thing for our criminal code. And so I hear you and I understand the point that we're trying to make. I think what we're simply saying is that we need to give individuals the opportunity to respond. Now, perhaps part of that conversation that we have with the committee as we work on these bills is if DMV is involved, because if there's the ones that you've pulled out, they're criminal in nature. Right. And so DMV is not notified of those until there is a conviction. And so there's two things that have to happen. First, DMV would have to be notified that there is a charge. Right now, we're not told about charges. We're
only told about convictions. Okay.
So that connection doesn't exist today, and we would need to do some work around getting us that notification. The second point would be for those lawyers who may have a client who has been involved in one of these horrific incidences, who is going to lean on our institution, criminal, institution of having due process and the presumption of innocence until proven guilty. Now, I'm no lawyer either, so I don't want to get too deep in that, but that's the process. But I hear what you're trying to do.
I feel like someone is going to sue the district. if you have a situation where we have charged someone with negligent homicide using a vehicle, so we know they're dangerous because an officer has an officer has arrested them, a prosecutor has charged them, we have a deceased individual at a scene, but then they can continue to drive, and in the process, if they kill somebody else, we knew they were a dangerous driver, the government, and we didn't do anything. That's the part that I'm trying to get to, is like, there has to be, for these very serious situations, some intermediate step that we can all agree on to take that person off the road. And I can acknowledge, you'll say, well, you know, people drive or revoke or suspended licenses all the time. But from a risk management standpoint, this seems like a gaping hole that leaves the district open to liability, because we know the person is dangerous. We know their driving privileges are problematic, and yet we haven't taken action.
So I would add to my response is that in most cases where an incident has occurred that is as egregious as what we're talking about, where there's been a vehicular manslaughter, and the person didn't leave the scene, or they were also injured, likely they are also arrested on the criminal charge.
And
right?
could be released, though.
They may or may not be released. That's not always the case. They may or may not be released, depending on what happened. In the case of them fleeing the scene, there's got to be some criminal investigation to happen to determine who it was. But once they know, then that goes back to your point, are we able to do something at the point of being charged? So it's the due process question and the presumption of innocence until proven guilty. And are we ready to take that first step into taking an action against someone who has not been proven guilty in a court of law?
Okay, I'm over my time. Chairman Allen?
I appreciate that. Thanks so much. I tell you what, since it is coming up on 1 o'clock, why don't we take a brief 4 or 5 minute recess just to let everybody have a chance to stretch their legs for a second, and then we'll reconvene for hopefully just a little bit longer, a couple rounds before we wrap up. But why don't we take just about a 4 to 5 minute recess? The time is now 12:48, and we will reconvene shortly. I think everybody is back. So if we can reconvene. There we go. All right, I think we can reconvene now. The time is now 12:56. So following just a short recess, we are reconvening now our hearing. So we had just finished up with Councilmember Henderson and starting another round of questions. So let me try to jump in. Deputy Mayor, you had kind of made a commitment to Councilmember Nadeau about trying to think about what would an IT system look like that could incorporate the different agencies, and I certainly appreciate that and look forward to that. But I wanted to pull this thread a little bit too about how we distinguish between the ways in which our systems can speak to each other. So, Director Spriggs, I might pull you in on this one. In your testimony, you had talked about how delineating between the police department and yourself, that you said that MPD's system of traffic violations is person-based, while DPW's system is a vehicle tag-based system. But our vehicle registrations are tied to a particular individual. So I want to try to understand this kind of disconnect a little bit more. Because in our pre-hearing responses, DPW had said that license plate readers, so your license plate readers can alert when MPD has said that there is someone who is wanted and this vehicle, is of interest. So that license plate was tied to registration. So it seems to suggest that there is at least some mechanism which by DPW license plate readers can make a connection between a plate and the individual that it's registered to. Why couldn't we do the same thing for traffic violations? Can you help me understand that a little bit more?
Hey, sir, yes. First of all, sir, we have to the tag number, but the registration is something different that we do not have access to. So in order to be a much more congruent along with MPD, it would have to be a system that can only do for us the tag, but also the registration to better able us to coordinate and to go across, perhaps even to go across to DMV lines as well, in order to do a total 360 on this. I think that, one, we need access to some of the systems that MPD does, but I also caution that at the same level because some of the information might not be needed for what we need to do currently. I say currently, as parking enforcement personnel. If we're taking on this additional layer or additional interest, then we need to take a look at what will that all include, not only the legislation part of it, but the responsibility to train and things that go along with that. And then that, should we be just for notification? Because that's all we could do, is to notify MPD's particular situation and then walk away from the situation itself. Because as you know, and as we've all mentioned before, I'm also concerned about the safety of my personnel out there, which is also critical.
Certainly. I mean, I think, and hopefully you and your staff have heard, I think everybody's concerned about the safety for your staff and, the escalations we have seen just from doing that routine parking enforcement. But if we have a system where the license plate readers are able to at least have some degree of communication that's coming from MPD when they say, this is a vehicle of interest, that means that somewhere along the line, their interest in a person is being fed into a place where there's a vehicle tied to that person, and then that plate is sent out for readers to alert when we see that. So that's what I'm trying to connect here, is that we have systems that can connect a person-based interest with a vehicle-based system, and that gap doesn't seem to be connected. Certainly, to your point, we want to make sure that the right type of information is accessible to the right people, but the systems don't even speak to each other, it seems right now, in a way that I think needs to change. And so that's one of the ways I think we can try to figure out some of our path forward as well. Let me turn to Director Robinson just for a little bit. We kind of talked about this a little bit. I just want to make sure we spend a little more time on this. And that was in your testimony, you kind of outlined the ways in which you think the current point system is more stringent than what the STEER Act, for example, is proposing. And it is true in some sense. That's kind of why I try to spend the time talking about our 99% versus our 1%. The threshold for a license suspension under the point system is lower than what is proposed in the STEER Act. In other words, it takes fewer infractions to result in that suspension. However, as we talked about earlier, the overwhelming share, not even close, like 99% of traffic infractions are generated by ATE system rather than a traffic stop. So if only 1% of all traffic infractions are being fed into a point system anyway, it's probably not capturing who we need to capture from an enforcement perspective and kind of a consequence perspective. Would you agree?
I would agree that the ATE system is capturing the mass majority of the speeders as opposed to the personal service tickets. So a point system, I think, would work if indeed I can identify the driver. And I think that is the DMV's, one of DMV's primary issues with the point system. There's two primary issues. The first is identifying the driver. The second is if I do not identify the driver and I'm only going after the vehicle owner, then there is no way that the point would be assessed on vehicles that are committing most of the traffic violation when it comes to speeding, which are out-of-state vehicles or drivers. And so without that piece of the puzzle being in place, identifying the driver, then I can assess points in the District of Columbia on district residents, the owner of the vehicle, but that will be the end of it. This bill will not be able to extend that same point system to vehicles outside of the District of Columbia.
But I thought earlier you told me you had been able to get data, for example, from other state DMVs about the drivers of vehicles.
So, okay, I'm able to get the name of the owner of the vehicle and the address of the owner of the vehicle. Points are assessed to an individual, not to a vehicle. So in addition to the information that I received today, I would need the driver's license number as well, but I don't know who's driving the vehicle. So other jurisdictions are not going to provide me a driver's license number because it's not necessary for me to assess a fine to a vehicle that has been positively identified as being at the scene of the violation. That is a fact. We can make that case as a district government, clear and convincing evidence that the vehicle was there. What we don't have the ability to do is to say with clear and convincing evidence who the driver is. So I would need more information than what I'm getting today. Yes, I'm getting the driver, the owner of the vehicle's name. I'm getting the owner's address so I can send them their ticket. I am not getting their driver's license number. That's the missing piece because points are assessed to driver's licenses, not to vehicles.
Are you requesting the driver's license number?
I do not because it's not necessary, nor do I think I will receive them because states will release information in the act of me needing it to do something that is necessary for me to do something that I'm legally required to do. Most states will argue a driver's license number likely, and I haven't asked, so I'm going to give information just based off of my interactions with the community. Will have questions. I won't say they won't, but they may likely ask a number of questions of why am I asking for a driver's license number when I do not know who positively was driving the vehicle, and why is it necessary? And nor would they accept my point. So let's, for a moment, assume that they give me the driver's license number. They're likely not going to still assess that point because when we get back to the compact, which we've talked about in earlier conversations, the compact requires that the state positively identify the driver such that the reciprocal point would be applied in the person's home jurisdiction. That is still missing even under the statute.
Okay. I know my time's up on this round. I think let's ask the next time and let's find out what their answer is. And there's always a chance too, I'd love to, on the next round, or if one of my colleagues wants to go down this road, to kind of talk about what could a rebuttable presumption also look like for that. Again, if someone's using your vehicle, maybe you create a rebuttable presumption that you got to show you weren't there. But my time's up on this round, so let me turn to Councilmember Henderson. I believe Councilmember Zachary Parker also just walked in. So Councilmember Parker, we'll turn to you after Councilmember Henderson.
Thanks, Chairman Allen. Director Robinson, I want to ask you about something that's currently already in regs. And I think actually in some of this conversation, as I said to one of the staff earlier, I feel like we needed a fifth chair here for MPD because they're involved in this, even though people don't necessarily see that as a main function of their role. So currently in the DCMR, if someone is pulled over for reckless driving and then an officer believes that they are under the influence, the arresting officer is required to issue a notice of order of proposed revocation or suspension to a person arrested for specific offenses and then file the notice with the precinct station clerk. Then it is supposed to be sent to DMV within 24 hours. Does this happen?
It does happen. It's not 100%, but it does happen. Okay.
So what happens once DMV receives that notice?
Sure. So once we receive a proposed notice of revocation that has been issued by an officer, we first need to validate that they've done everything properly for us to move forward, right? So if the form is not properly filled out, is not completed, they have not made the right markings that we need in order to move forward, so we do that first. Once that's been satisfied and they've met all the criteria that they needed to meet legally, then the individual is required per that notice to schedule a hearing with DMV within 10 days if they are a DC resident and within 15 days if they're an out-of-state resident. So
can they continue to drive within those 10 or 15 days?
They can continue to drive within those 10 to 15 days. And if they do not respond within that time frame, then an out-of-state individual will lose their driving privileges in the District of Columbia. For in-state DC driver, then there is a 30-day period because they're required then at that point to get into the Ignition Interlock program. And so they're then afforded that 30 days to get into the Interlock program. If they do not satisfy that requirement in that time period, then they go into a phase of indefinite suspension or revocation until which time they satisfy.
This is before they even get to a judge.
That is, well, they should have seen a judge, but the process will continue to move. So the notice they get on the side of the road tells them they must go to the DMV or contact us to schedule a hearing.
Okay, so
but they don't do that, but we make sure to.
Well, let's test. All right, so you gave us data that said FY23, 424 convictions came to you guys from Superior Court. Presumably, those 424 individuals got pulled over by somebody, because, right? That's the only way they would have made it to the court. Mm-hmm. Do you have information of those 424? How many of them actually appeared before the DMV?
Which year are you referring to? Because
FY23.
Okay. FY23, 494. Is that the number you're referring to?
Or
I'm trying to make sure I follow you because I gave so many charts and graphs.
Yep. Hold on.
I want to make sure I'm.
Yep. Sorry. 494.
Okay. All right. So, of the 494, then no, that is not all pulled over in the District of Columbia. That includes, if you look at the chart, DC drivers who are also pulled over for drunk driving or driving under the influence in other jurisdictions as well.
Okay.
326 of those are district issued on district road to district drivers.
Oh, I see. Okay.
Not district pulled over on district roads, but it could be district and in-state.
Okay, so that's the clarification I need for
Yes.
this chart. Okay, so DC means we pulled you over.
We pulled you over.
Maryland is somebody else, in Virginia somebody else, or others. Therefore,
That's right, but
so
those are
on.
DC drivers.
Correct.
right?
Okay, so let's then focus on the 326.
And that includes DC drivers and out-of-state drivers pulled over in DC.
Okay.
Because we will take your privileges if you're out of state. I can't suspend your license if you have an out-of-state license, but I can suspend your privilege to drive in the district.
Hard to enforce, but continue on.
Okay.
Okay.
I can suspend your privilege to drive in the district.
Okay.
If you have a DC license, then I'm the holder of that license, and I can suspend the actual license, which will prevent you from driving anywhere.
Okay, but
Now-
of the 326, how
most-
many of them came to DMV in the required time that they were supposed to?
Within, let's see, well, we had a total number of hearings based on the 3340s of 76.
All right.
So a low number.
Yeah. So that's either something happened on the end when they received the paper, or the paper didn't make it to you.
No,
No?
I received the paper, right? So if you look at question 1
Okay.
that was submitted, it gives you a breakdown of the actual 3340s or proposed revocations that we actually received.
Okay.
Right? So you can look at it by fiscal year and you can
Oh,
see
I
the
see.
top
Okay.
line number of what I received. I then go on in that same chart to let you know how they're broken down, whether it was for drug and alcohol, was it because the person refused to take the chemical test on the roadway. I even break it down if the individual was qualified for some other mental condition that would disqualify them from driving at the time, meaning epileptic seizures, diabetic seizures. Those are things that a police officer could notice you were having erratic driving. That would be the due
Right.
reasonable suspicion to pull you over, and when they do pull you over,
There's some
they
other
determine
medical-
there's something. It's not alcohol. They don't smell alcohol, but there's something wrong
Got
with you.
So here's the thing. What happens if an officer submits the paperwork late?
If they receive it, if we receive it late, then it is not actionable on the DMV side
So
under
we had
current law. The
100
current-
people who an officer believed was driving under the influence. They issued a citation, but you all received it late, so nothing happened until they were potentially adjudicated in a court of law.
That is correct. So it doesn't mean they get off scot-free. It means that the administrative hearing portion of it is not actionable.
Right.
But the conviction, as you suggested, from the Superior Court is still in play, and the individual could have punitive actions at that point.
But, so there was someone during the public witness testimony who said, this bill isn't necessary because we already have an administrative process.
That's right.
Said administrative process isn't actually capturing people. Like, if I think about what's happening with Superior Court, so they have 11 vacancies right now of judges, 5 other judges who are out. So that's 16 that they are down, which means while we are saying we want someone to have a speedy trial, it is not happening as quickly as we think. And so one of my concerns, again, is I know you had a DUI, or the officer believed that you had a DUI, and yet you get to keep driving and doing more bad stuff until we finally get around to adjudicating you in court.
And this is where I think we can work together,
Okay.
right? So I think the way we work together is we've done some research of other jurisdictions to see, is the rule that's on the books for us now that says by law you have 1 day MPD to get that to DMV, but then we enforce 3 days because we have to account for the weekend, and holidays, right? So MPD has 3 days to get that document to DMV for it to be actionable. I think there may be an opportunity for us to expand that window for MPD and for MPD perhaps to look at their internal processes to make sure we get it. DMV is already in conversations with MPD to try to assist them in ways, how can they get it to us? Because they don't have to physically bring it to us as they have done in recent past. We've built our customer relations system such that they can scan it and email it to us, and it goes to a very specific file for it to be made actionable. So we've been trying to work with MPD to say, hey, we have this number of notices that we can't take action on because we received it beyond what the law allows. If there's a way that we can work together. So that conversation has happened. So we've already started that process, but there may be more we can do through these bills to like loosen that up for me to such that my period of action is longer, to work with MPD to ensure that they have ways to get it to me, including maybe automating the 3340, which is what the DMV would prefer, because most of their tickets are issued through an automated handheld device. There's no reason that, in my opinion, I haven't talked to MPD in fullness about this yet, but is there a way that their 3340 can flow over just like their tickets when they dock the handheld system, much like DPW's tickets?
Okay. I'm way over my time, Chairman Allen.
So this is places I think we can work.
Okay. I just want to say this kind of highlights a situation, even when we talk about crime in general, right? Accountability, swift accountability needing to be there for a deterrent. When I have individuals who, oh yeah, I got a ticket for a DUI, but nothing happened, right? The behavior continues because you don't have any incentive in their minds to change because it goes to that fact of like, oh, well, DC is not going to do anything. Anyway, Councilmember Allen.
Thank you. I appreciate it. Councilor Parker, let me turn to you for a round.
I am still pulling up material. I'm happy to yield time to my colleague if she wanted to continue on. Otherwise, well, Chair Allen, I would like to yield this round to Councilmember Henderson as I still pull things up as I just arrived at the hearing.
We're going to go around for another round if we'd like. So, Councilor Henderson, if you had another question you want to hit real fast, otherwise we can keep going and come right back around.
Why don't you go ahead, Councilmember Allen? I just have one more round and then I need to run.
Got it. Okay.
Okay.
Well, I'll just say I wanted to go ahead and jump in on this issue just real briefly before I turn to some other questions, and that's, I appreciate my colleagues' questions on this. I think the reason why we're focused in on the 3340s and the forms is that we've got the systems that we've got don't seem to be working, and there are gaps, and that's what I think we want to collectively try to work on. Earlier this year, we found that there were a whole bunch of people that were supposed to have suspensions and that wasn't happening. And we worked through oversight, we worked through communication with agencies to help figure out what was going on and go at that issue. What felt fairly newsworthy to me of earlier in this hearing is understanding that there's only 8 people on the Interlock system, but we realize there's 335 that should or could be, and that outreach is now happening. So I do think it is appropriate for us to be pushing aggressively on trying to see where those gaps are and then be able to find out. Because if, to my colleague's point, if there's legislation that you feel like is going too far, I want you to understand where it's coming from, is that we feel like there are dangerous drivers on our streets and the systems we got aren't getting to the problem. So I don't need to kind of hit on that again because I think that she asked those questions, but I think that's certainly where I think it's coming from. So let me spend a second asking about one of the questions, which is, as we look at implementation on one of the pieces of legislation. And Director Spriggs, I think I'm going to start with you a little bit on this. So on the STEER Act, Director Spriggs, you had mentioned that inclusion of reckless driving and aggravated reckless driving in the definition of immobilization eligible offenses would be problematic because they're criminal offenses, which DPW doesn't have the ability to identify in your system when checking a tag. But DMV does assess points based on those offenses, I believe. So as a sister agency, would that be in your system? And does this hit your concern around what you would or wouldn't want your parking enforcement officer from an MPD information to know? Can you help me understand where we could still achieve the same goal if you think there's an implementation problem with the way that it's laid out?
Yes, sir. I think that there's perhaps a better way that we could work collaboratively. Right now, DPW can only identify parking violations in ATM moving. In addition, sir, we've already do towing enforcements of 2 tickets that are unpaid within a 60-day period. So we're already doing those type of things that is part of our responsibility. But I am concerned when it talks about the ability to determine whether a vehicle driver has been found liable or guilty for reckless driving or aggressive driving, because those are strictly criminal offense, not parking offense. So
So I guess you said earlier you want your team to be somewhat neutral to whatever, and the way that I heard that, and correct me if I'm wrong, is that you don't want your staff to be, you want your staff to just basically say, is this a violation that is a boot eligible event or not? You don't really care what's behind it necessarily. It's just you want the neutrality of kind of a black and white answer, like it is or it isn't. And in that regard, if we work so that the DMV has assessed points for reckless driving, aggravated reckless driving, and that just pops up that says this is boot eligible, is that more of what you're looking for, so that you don't put your staff in a position of kind of discerning, but really it's just more of you want a black and white answer. Either it's boot eligible or it's not.
No, sir. I want the guidance and the latitude to actually do that. Oh, Gabriel?
So I would like to add, council member.
Yeah.
So when we talk about reckless driving and aggravated reckless driving, we're talking about criminal offenses, right? So it's not based on the vehicle, it's based on the individual. So this instance is in the complete reverse of what we talk about when we talk about ATE tickets, where it's about the vehicle and not the individual. So when DMV sends information to DPW, we're sending vehicle information about ATE parking and moving violations. So I will say, I mean, there is a possibility, as you've suggested, I mean, as we work to try to figure out ways to shore up the system, that DMV will receive enough information from Superior Court that will include the vehicle information such that we can include that in the boot immobilization notation that we send to DPW when a vehicle is boot eligible. So there's work that could be done to achieve this, but it's not based on the vehicle. So there would just need to be more work with Superior Court to ensure DMV receives the right information, because if someone is charged for reckless driving, I won't use myself as an example, if someone is charged with reckless driving, they may not be driving their car. So I can't simply say I'm gonna use their driver's license number, which I should have, and then attach that to their vehicle because it may not have been their vehicle that they were driving at the time. So I think we can get there with some more communication where DMV will receive enough information such that we can attach this to our immobilization notification eligibility that we send to DPW.
Okay. Feels like these are the places where we're trying to connect the dots, right? That if you've got an individual who's repeatedly dangerous driving, you've got somebody who is known to you, you're able to assess the points. I want to take the tool away from them that is the thing that creates the hazard and the danger on our streets. And that's why we want to be able to have that vehicle then be able to be boot and tow eligible, and then have the team that's able to take that action know that information.
It's certainly a conversation to be had. I hope I'm making it clear that it's something that I think the DMV is willing to work with the committee on to figure out ways to ensure that we receive the information that we would need in order to give DPW the notification that it would need for a potential immobilization opportunity.
Okay. Let me ask one more question before this round wraps up, and that is, in the testimony you talked about, well, the district can already boot and tow a vehicle with 2 or more unpaid tickets, which are more than 60 days old. And that's true, but again, it falls back on an entire system based off of unpaid violations rather than the violation itself. So how many speeding violations do I need under our current system that I can just keep paying? Like, how many speeding violations can I receive, even though I just keep paying them, though, before our system would deem me a dangerous driver and suspend my license?
So in the case of an ATE ticket, a driver is not identified. A vehicle is identified. So there is no system currently in place to identify a driver. Now, one can make the assumption, and I agree, that is likely the same person, but do we know who that same person is the question. And I think it gets to a slippery slope.
I know what the car is, right?
You know who the car is.
If I see a car, I mean, how many times does a car have to be driven over and over and over again, and even if those violations do get paid? And that to me is what this legislative reform is about. And again, I talk about this with an open hand to say, how do we work on this together? But our system is based off of, let's only focus on the people who have unpaid violations. There's also a system where people say, I can buy my way out of consequences. If I just keep writing a check, I can keep going. And I think that the DDOT director highlighted that actually a good number of folks, they get a ticket once, they get it twice, and they're going to change their behavior. That's what we want. Again, our AT system is not supposed to be about revenue. It's about safety. But we know that we've got folks that will continue to drive dangerously, and that's what we're trying to change. And so I know my time is up, but that to me is kind of the kernel of what we're really trying to go after, is get after the dangerous driving, the excessive speeding that we're just seeing over and over again. And we've got some tools that are effective, and that's great. Let's work on how we amplify and maximize those. But for the spaces that aren't, I think this package of bills are trying to get at that and then welcome the feedback about where changes might be necessary, but how do we move this forward with some urgency? All right, Councilor Parker, did we give you enough time to get ready for your round?
Yes, thank you.
All right, so, and actually, I can check to see if Councilor Henderson, are you back? Or maybe you never left?
I'm back.
Okay, so should I go back to Councilor Henderson first and then go back to Councilor Parker?
Sure.
Appreciate you. Appreciate you, Councilmember Parker. Thank you. Okay. Director Robinson, so you noted that neither of the bills that I introduced accounts for vehicles owned by organization, a trust, or some other entity who's not an individual. Do you know approximately how many vehicles fall into that kind of category?
I'm happy to report back to the committee on those numbers.
Okay, and Director Kirschbaum, similarly related, how do you all treat those types of vehicles for the purposes of ATE? Or Director Robinson, or?
Sure. I mean, those violations do go to the organization. If it's a DC government employee, it's going to come to the agency, and they have to track down who was driving it. So that doesn't stop the tickets from flowing.
Okay. Do we have any egregious organizations or trusts? Right, if we're talking about individuals, right? I know how individuals, it'd be hard to track down. For organizations, though, we know where you are, and we have other levers that could be used to sort of change behavior.
Sure, so when we talk about, well, I'm getting a number here, so I don't know which is that for trusts or individuals or companies, but individuals are moving more and more to moving their vehicles into trust, right? But for the sake of,
but why?
Beneficiary, it reduces the ability to have to go to probate if the individual was to pass away. There's a number of reasons why individuals put their assets in a trust.
I've heard that for houses, but not for vehicles.
Oh, well, it's very true for vehicles as well.
Interesting.
So that's why I called it out, is because it's important that if we're really trying to get at all the population that is potentially violating our rules of the road, then we should, consider all of the potential entities that could include. So organizations, yes, we have organizations that get their fair share of tickets. In fact, some of them may call it just the cost of doing business. If you're looking at, say, a delivery company or what have you, that's just the cost of doing business. So when you start looking at the number of violations and what actions we're going to do to mobilize their vehicles after they get 8, 6, or 10 ATE tickets, which admittedly so they should not have gotten, but those are organizations that's not included in this bill currently.
Okay. Speaking on other tickets, individual related, I guess not truck related, or it could be trucks. Director Spriggs, our colleague, Councilmember Lewis George, posted this video of coordinated enforcement that took place on Georgia Avenue and Farragut a little bit ago. I live like right over there. So I want to say kudos to your team on that front. 2 weeks ago, though, I was over kind of in the Noma area, and I saw an individual who was waiting on a DPW vehicle to come to release their boot because they had paid their ticket, which begs the question, where are we on self-release? At one time, I know it wasn't enough money and RFP and this, that, and the third, but...
Well, I'm not even going to go there with you. What we have done is we have figured out the self-release boot that we wanted. We did put it out. This year we got additional funding. We got funding for that. The total, I think, is $950,000 to put it out for bid. And that's exactly what we're doing. We're getting the statement of work approved by OCP.
Okay.
But the other thing that I cautioned about in our previous testimony, ma'am, we said that it was between $800,000 and I think it was to $3 million. So, but we do have the money. We did put it out there. We took into consideration self-release boot on the wheel versus on the windshield. So that's what we looked at.
Okay.
And we feel pretty confident. So we look, that should be out by the end of this month.
And your RFP isn't to completely replace the program, right? We're looking for a number that could start it out, see if it works, see if we like it, and then make a decision from there.
Ma'am, this right here is a pilot program.
Okay, great.
And that's how we plan to attack.
Okay. On that, my staff is asking if we have gotten any sort of update around the infamous boot man that is often discussed at these hearings.
You mean the boot man, the people that are hiring to release the boot?
Yes.
Is that the boot man? What we have done, we have notified MPD in reference to the boot man. So that's where we are with that.
Okay, so we've notified MPD. All right, I have like a lot of questions for Chief Smith on performance oversight updates on that front. Director Kirschbaum, I want to go back to ATE really quickly. So when former Director Lott was here, we were having a sort of a back and forth around the ATE camera worksheets, because I feel like if we're going to deploy hundreds of new cameras, we have to provide some sort of justification to the public as to why we pick a specific location beyond just saying we analyzed the data. Especially when I know that we have more to say than that. Where are we on this? Now, I met with a former director and his team in terms of their complexity, staff, X, Y, or Z, but there has to be a way for us to perhaps do a more simplistic translation from all of the data you have to be able to provide the public with an easy way to see this is why we chose 4th and Kennedy or whatever the location might be.
Councilmember, I couldn't agree with you more. We need to be transparent about the why, and we want to be. And I know you dug into this a few months ago, and we actually did share with you the pretty expansive worksheets that are created. And I think you were relieved to know that there is a lot of effort and analysis that goes into it. Our goal would be, instead of having those worksheets get shared broadly, to actually have a digestible summary that explains it in language that we know residents are going to understand. There is data and language in those worksheets that I don't fully understand. We're not the intended audience. I worry, and every time we have sort of experimented with the kind of sharing some things, the amount of back and forth that we get with residents who want to dig in, they're not confused, it will expend so much energy when I think what we really want to do is just give them the why. And I think our goal would be get this dashboard set up. We're going to get it done this year. We're going to have a summary that explains it in clear terms.
Okay.
If I'm getting
This calendar year or this fiscal year? Just clarifying.
I'm going to say this fiscal year.
Okay, because that could be a year.
In FY24, well, 12 months, but it won't be in this calendar year.
Okay.
And I am very optimistic that that will resolve the questions. I also just wanted to underscore, there are times when the worksheet may say this segment, this intersection could benefit from an ATE camera, and then we don't move on it because there's also another review that's really just about the logistics. Do we have a pole? Is it visible? Are there too many trees or things blocking? And so I also worry if the worksheet gets out that's saying yes and then it doesn't happen, there's going to be a lot of back and forth trying to justify why. So I'd rather let us synthesize it and put it in this dashboard.
I could sort of understand that. It's the District of Columbia. We got a lot of people who ask us a lot of questions. We got a litigious group of individuals in our jurisdiction. But I don't feel like the fear of a question should be the reason why we don't provide transparency. Because someone might ask 2 more questions after learning about some particular information. I want people to have trust in the program. And if we are holding back on that information, that feels that way. And I can totally understand, too. There might be a reason you said, yes, it might need a camera, but you know what? We'd rather put a speed bump in because our goal isn't to ticket, but it is to literally change behavior. And I've said this before, right? I don't think ATE cameras are the be-all here. Sometimes I need to physically stop your vehicle and maybe bust it up once or twice in order for you to sort of change behavior. I'm on Team Bollards, but, you guys have told me why we can't install them. So nonetheless, that is my time. Thank you, Councilmember Allen.
Councilmember, I have some
Director.
numbers for you if I can really quickly.
Oh, okay, yes.
So you asked about the number of vehicles registered to non-individuals.
Yes.
So currently we have 1,054 to non-individuals, but we also have 1,382 vehicles registered to people with ID cards, identification cards, so there could be no points or anything assessed to that. And then there's 44,073 vehicles that have a co-owner associated with the vehicle. So if that vehicle was immobilized or otherwise rendered, not drivable, then both parties or the entire household would lose access to that vehicle, even if we stop the individual with the bad driving behavior from driving. So I wanted to provide you with the numbers.
Thank you. Councilmember Allen?
Absolutely. Thank you very much. Councilor Parker, let me turn to you.
Thank you. Many of my questions are going to focus on process. Director Spriggs, good to see you. I will start with you in DPW. In the responses we received, it is reported that DPW has 6 booting crews for the entire city. Is that accurate? Yes, sir. And it seems like part of the concern from the agency with having interagency communication systems, which might mean, hey, there's a car over here with fake tags, or there's a car over here that needs to be booted or towed, is that might disrupt the routes that are already predetermined for those 6 booting crews. Roughly how many individuals make up the 6 booting crews? Because I noted you also said there's 14 people that are staff with booting responsibilities in general.
Yes, sir. The actual booting team consists of, you're absolutely correct, it's a total of 14. 2 people per equals a booting team. So with 2 people per on the booting team, what we're planning to do, sir, is to take 2 of those booting crews and put that on the afternoon shift, because we do believe that we're missing the afternoon shift of 2 to 10. Right now, we mainly do booting in the early morning, between 6 and 2 p.m. And we plan to do that because we believe that we're missing an opportunity the people that come into the district for activities and for different types of events. So therefore, we plan to take 2 of those crews, total 4 personnel, and put them on the afternoon shift 2 to 10 to get that population of violators.
Understood. And has the agency done any analysis on scaling booting capacity across the city, given the numbers of deaths, the numbers of violations that are continuing to rise? So while we have 6 booting crews, is there an analysis that says we actually need 10?
Sir, the number is, there's a couple things in which we are doing. We realized that we could do more. With that, we recently had specifically a parking enforcement job fair it was on the 17th of October, where we know that we need additional MVO drivers, number one. And number two is just that we need more tow drivers. We need not only ticket writers, but we also need more tow drivers.
Yes. So what is the capacity DPW would say it needs right now? Or let me rephrase that. What would be the capacity DPW would say is ideal?
I do not have the figures on what is ideal. All I could tell you is just that we are increasing the number of tow truck drivers. We are increasing the number of ticket writers. Okay. But we're also looking at now when we bring those on, additional truck drivers, additional booters, additional riders, once we start doing the front end, I will call that the front end for what I do, then the back end is just then where would I put the equipment that I have passed scofflaw, the booting violation has been there, that has been booted for 24 hours. Where do I take it to the impoundment lot?
So is it fair to say, I'm just pressing here.
Yes, sir.
DPW is attempting to hire more folk to do booting, ticketing, towing. However, there isn't a stated goal.
I'm not saying, I am not familiar, I have not developed a stating goal based on trends, but I do know that there are initiatives and things that we're doing. And I think it's also important that we understand what I will call the back door. The back door is currently, sirs, I have 1,092 spaces for violations that have reached the goal that it needs to be impounded. With that, the vehicle stays with me for 28 days. There are things in which we've done to help ourselves. In coordination with my sister agency, we are now did an MOU to allow us there's a person that will strictly be dedicated for DPW to give me registration and things that I need so that I could either tow or, to either scrap the vehicle or auction the vehicle so that we will create space.
So what I'm hearing you say is there's an operational challenge that more booting calls for more process on the back end to process those vehicles.
Yes, sir, it is.
I got you. One of the other things you flagged was that the agency generally is not equipped to identify fake tags, and that may not be the exact wording that you're using, that perhaps there may be a better agency for that. And I agree with Councilmember Henderson, we perhaps should have MPD here at this hearing as well. I know neighbors complain about fake tags all of the time. Can you just speak and give more information around how does DPW identify fake tags? Because on one hand, I'm hearing you say, well, we shouldn't create a registry. We're not the best agency for that. And that's not on us. At the same time, DPW has the authority to boot or tow a car that it deems has fake tags or expired tags, I should say.
If you're talking about expired tags, sir, yes, sir, that is.
But aren't there some tags that are just clearly fake that I can literally with a marker just say this is a fake tag? And are you suggesting that DPW or a staffer wouldn't be able to impound that car?
Sir, what I stated earlier, if those such things that is so egregious that it is that obvious to that, then there's a fine failure to present failure to attempt to display current tags. That way, that is an offense in which we can take action if it's egregious. There is can I say that I identified what would you say, a counterfeit or forged tag? But if it's egregious, yes, sir, there are things in which we can do and which we have done, sir.
Okay, one more question, then I'm going to come to Mr. Robertson, Director Robertson. I'm noticing my time is dwindling. One of the other frustrations that I hear all the time from Ward 5 neighbors is I've seen this truck or van or car sitting in my neighborhood for weeks. I call, and I understand DPW has its own process. If I'm not mistaken, you have to, before being able to tow the car, give it at least 24 hours warning. Is that accurate?
Yes, sir.
Is there a desire to look at that so that there could be more immediate impounding? For instance, if there was a car with fake tags, could I just call someone, perhaps DPW, to say, hey, I need this car off the block right now because I'm seeing guys go in and out of it and it has fake tags? To give it 24 additional hours just seems like a prolonged window of time. And I know this may seem different than the bills that are before us, but what I'm getting at is part of the frustration I'm hearing from colleagues that there are some operational challenges with how we're currently enforcing the rules. And so is that even something that DPW is currently looking at?
Yes, sir. It is something that we are currently looking at, and there has to be a better way, and that we need to be able to quickly respond. So we are looking at technology, we are looking at ways and bringing on more people so that we can be better able to take care of those types of issues. It is not something that we have overlooked, but it is something that as we move forward, we will bring in more people, then we can begin more target enforcement for those kind of calls or types of information that we do receive. Yes, sir.
I appreciate that. That is my time. Director Robertson, I'm not sure if we're going to have another round, but I do want to follow up on some of the questions related to the 3340s that you discussed. But thank you.
Councilor Parker, we were going to start wrapping up soon, so if you wanted to ask a couple extra questions here, I'm happy to give you a couple extra minutes, and then I've got a final round, and then we'll start wrapping up.
Yeah, I caught the tail end of the exchange with Councilmember Henderson, and so if some of this is repetitive, my apologies. But I'm looking at the pre-hearing responses, and can you just characterize again if, or I'm going to say what I recall you suggesting, that if the officer submits their paperwork late, then enforcement-wise, when the DMV brings that individual in for a hearing, there's not much that can be done enforcement-wise on the DMV's end. Is that accurate?
If it's late, then it's not actionable on the administrative hearing side, which is the responsibility of the DMV. It is still actionable on the court criminal side, such that we can receive a conviction from Superior Court.
But in effect, which means that individual might be able to keep their license during that period of time.
That's correct.
And when we say late, what is the window of time you're talking about?
So MPD has 3 days to submit 3340s to us.
And we also know, and I know this isn't what you're suggesting, but just thinking out loud, we also know MPD is stretched thin right now because of its own staffing challenges. So I imagine what you might be hearing from MPD is, hey, we're kind of overwhelmed or swamped, and therefore I got this to you on the 4th day. And so therefore what you're suggesting is that would not be admissible for that administrative hearing, and therefore that person would not necessarily lose their license.
Well, I would say the DMV, understanding that fact, have done a number of things in coordination with MPD to aid them in their ability to submit a 3340 electronically to us in recent weeks or months. We've been working with them to say, hey, there's no reason for you to have an officer dedicated to drop it off. Electronically send it to us, and better yet, let's have a conversation for you to automate the process like you have your tickets. And so when you dock your ticket machine, it comes to DMV automated, much like DPW's parking tickets. When they dock their issuing device, we get it within the 24-hour period of time. Additionally, we've done other things with MPD to alleviate their load, understanding they have other things they're willing to do with virtual hearings. It used to be a requirement that MPD officers had to come to the DMV and sit before our hearing examiner along with the individual that's been charged and mount the government's case, and the individual mounts their case. They had to come physically. Over the last year or so and a half, we've introduced virtual hearings so they can do it at their district, at their precinct, so that they can save time, no travel, and they can do it on camera. They still have to be there to mount the defense, but they don't have the travel, they don't have the wait time that they used to have. So we've done some things to help MPD in this process.
Two quick questions, Chair Allen. I thought you were suggesting earlier it is a desire for MPD to move towards a virtual ticketing system, but it also now seems like you are working on that.
So we have a virtual electronic submission process that they're working on now. I would like us to go a step further and to have an automated 3340 submission process, much like they do their enforcement tickets for speeding.
Got you. But just to be clear, the 3340, there is no work currently happening to make that automated.
Not that I'm aware of. It is a 3-part carbon document. One piece goes to the customer, one for MPD, and one to DMV.
Okay, that is something we certainly can follow up on. And then I just wanted to follow up on page 3 when you have a further breakdown of the 3340s. Here it says 3340 not submitted or not completely filled out, and therefore there is no action. In fiscal year 24, there is 4. How are you differentiating that number from the 109 because the officer submitted late? Can you just expound on?
So are you on the chart for show cause hearings pursuant to Form 3340?
Yes.
And
So the no action based on, 3340 not submitted or not completely filled out, and in parentheses it says no action. Is that on the DMV
so
side?
So there's two different things. There's one with the form being late, and so it's not actionable. But then a form can be deemed not actionable if it's not filled out properly.
By the officer.
By the officer.
Got it. I got it. Okay. Thank you all. I will just echo what I'm sure has already been shared, is that we want to advance Vision Zero here in the city, and it has been a failure. And that's on all of us. And as we know, traffic violence is increasing across the city. What the council is attempting to do is put forth solutions. I appreciate the nuanced perspectives you each have provided around some of the challenges with what is presented here, but my hope is that from this we can put together a comprehensive package that moves the needle forward. What I'm also very aware of, which is connected to my questioning of you, Director Spriggs, is we need to do more on the staffing side. I'm also I recall when the council received the mayor's budget, there were many FTE cuts in DPW. That's not your fault. But that means that if we're taking and undermining and undercutting the very people that will help us enforce our safety laws, we aren't necessarily living up to the ideals of Vision Zero. So thank you all for your time. And Chair Allen, that's all I have.
Thank you very much, Councilor Parker. And to your point about hoping we're going to move a package forward, let me just go ahead and commit to you, we will be. And this hearing has been helpful. The public hearing that we had, where we had just near unanimous support for this legislation and these efforts. And we, I want to make sure the public knows we also had a very constructive kind of pre-meeting with many of the agencies and the representatives to kind of work through legislation as well, and where their feedback is. And I think today's conversation moves that forward as well. So we will be moving this forward, and we will be moving forward urgently, because I think that's what the moment requires us to do. But I'm looking forward to working with all of you to kind of help make sure we get that in a place where my hope is that we're going to land in a place that everybody is supportive of the package that we're moving forward. Before we wrap up, though, and I do want Director Kirschbaum, if I can ask you a couple of quick questions, and it is related, of course, to safety, and that is on our roads, but with our bus lanes and with the clear lanes. You had gotten back to us earlier today with a letter in response to something we had sent a while back, asking for an update on DDOT's clear lanes enforcement plan that was delayed. And so I just want to ask you a couple of quick questions on this before we wrap up. In the letter, you outlined that since July, there have been about 23,000 warning notices that have been issued, and that was intentional to have a ramp up of some warning notices before the actual citations went. Where the delay came in is in switching over to that the actual enforcement there. For parking at a Metro bus stop. That enforcement you announced will begin in 2 weeks on November 15th. However, for people that are parked in the actual bus lane itself, that you are saying you are not going to move forward with enforcement on that until the fine changes. So I guess the first question I was going to ask you is, the council had to move emergency contracting for this. At that point, the fine was $200, and this was not brought up at that point, was it not?
Councilmember, I'm not clear if there was a deep dive or discussion about the fine amounts. I do want to say, yes, we're very excited. We're launching on November 15th. While we are going to, in this initial phase, focus on parking at the bus stand, the $100 fine, that is about 80% of the total warnings that have been given out over this period. So we do think that that's going to capture the vast majority. We will continue to have warning notices for those that are either driving or parked in the bus lane beyond the bus stand. This is a new violation. We think the extra time for warnings is not a bad thing. And as you said, we also are reducing the fine amount so that they're consistent and, quite frankly, really in line with looking at all of the ATE fines writ large. And so I think this is the right thing to do. I think the program impact will happen now. It's already happening in terms of awareness. And again, most people want to comply. They get the warning. They know someone's watching. So I think it's going to yield big results, even if we're doing this in 2 phases.
You mentioned, though, that the driving or parking in a priority lane is the new offense. When did that go into effect?
I think that's going into effect. I'm actually not, I think that's going into effect now. I think it is new, and it was supposed to go into 2 when we're moving it to 100. I'll tell you, I don't really know the history. My understanding is that we've been historically just focused on the bus stand, and because we haven't had priority bus lanes, I'm not quite sure what the enforcement has been, because they're a relatively new phenomenon.
Okay. The rule's been in effect for over 2 years. So I don't know how that's new, but the bus lanes themselves are literally painted red and say bus only. So it's pretty clear, right?
Yes. And my understanding is that there have been ticketing, again, because it wasn't with cameras. I think it's a really challenging thing to catch people to do because they're often moving. They're often there for a very quick minute. So this is why we really need cameras to enforce it and make it work. And I think it's, again, people who have been compliant, that's great, but I think there's so many people that have been able to get away with it that it's diminished the impact, and the cameras are going to fix that.
I'm 100% in support of having our cameras be able to be used for enforcement here. It's why when the mayor asked, we moved emergency support in the spring to be able to purchase the cameras. It's why this has been rolled out. It's why we were excited when this began in July. It's why we were excited when we thought enforcement was going to actually begin in mid-September. And here we are in mid-November being told that actually you're not going to enforce that unless there's a change. And at no point was there a discussion about this until this letter this morning that says you're not going to do enforcement until this. So it is frustrating to say that this is now an excuse to not move this forward. But I want to work towards a solution. I'm much more interested in a solution than an excuse. If the fine amount is the difference, which is now the first time it's ever being brought up in the years of all of this and the millions of dollars spent in bus priority lanes, then let's figure that out. But you also built a budget that had, for FY24, had revenue projected to be from this. You expected to have $2.1 million in revenue from these citations. What does the delay in not moving forward with enforcement mean from a revenue projection standpoint?
So as you mentioned earlier, the enforcement is starting November 15th. While it's going to be limited to the bus stand violation, that is 80% of what these warnings have yielded. So enforcement will begin, again, as you know, this is never about the revenue, but my understanding is that the estimates vis-a-vis the bus cameras were very low. And I am not concerned that the volume of tickets that we're going to start writing November 15th won't result in those estimates being reached. Again, it's a small portion of the violations that are going to be postponed until January.
And again, I don't really care if it's $200 or it's $100. I think that what matters most is the swiftness of and the certainty of there being the consequence, right? But if you put forward a budget that based on a certain fine amount, and if you're going to cut that fine amount in half, is that not going to have an impact on the revenue? And this is important because if you're going to propose a regulatory change, or if we're going to have to propose a legislative change to that, we can't be anti-deficient. We can't decrease it, or you have to find funding from somewhere else to fill that. That's what I'm trying to make sure I understand, how you're going to cut that fine in half, but then still think there's no impact to revenue.
And I would like to revisit this after 2 or 3 months of the bus stand enforcement happening to see what the revenues look like. This is new. We don't have a crystal ball. And as a result, the estimates in terms of the revenue for bus lanes was incredibly low. I think they estimated maybe 1 or 2, a handful a day. So I really am not worried that we're not going to hit those we're not going to hit that revenue number. I think we have to just let's do a month or 2 with the bus stand alone and see where we are before we start worrying about funds, any anti-deficiency or revenue concerns.
I appreciate that. The thing is, I have to worry about the funds as the appropriator, right? So we have to, every decision we make in the budget we put together has to be based off a certain set of assumptions. So at some point, somebody made an assumption and said, based on this fine amount, this is what we predict, and this is the revenue. And the FY24 budget that we're in right now said $2.1 million. So do you have from either your agency fiscal officer, from a budget office, something that says if you drop this in half, you're not going to see an overall revenue decrease, or that you're absorbing it and have the funds somewhere else? Which could also be an answer. But do you have that so that we know how to be able to move forward with this?
So first and foremost, I do think that assessing what the fine amounts are, and I know you said I don't care what they are. We care what they are. $200 fine for being in a bus lane when it's $100 fine for speeding 11 miles an hour over the speed limit. We need to have a sensible rate of fines commensurate with the issue. And so I really feel like having our bus lane fines all be the same amount. I really couldn't explain or justify why these 2 are 200 and this one's 100. So this is the right thing to do. It's equitable. It's fair. That's sort of the why. I cannot tell you today.
Director,
we haven't started the program.
This literally this morning is the first time that anybody, DDOT has brought this up. You've built an entire system and spent millions of dollars on bus priority lanes with this current structure, and now you want to change it. Okay, we can change it. I have to be able to figure out how do you make sure that it's paid for within the budget since we're already in the fiscal year. That's what I'm trying to make sure I understand.
Sure.
Do I want to have fair, equitable fines? Of course, but we have taken years worth of actions based off of what we believe the fine amount to be. And now for the very first time ever, we're finding out this morning, well, actually, we're not going to move forward with this part of this because we don't like the fine structure. We think it should be changed. If we need to change it, we can change it. But I also have to make sure it's paid for since we've already essentially paid for it within the budget that we passed. Right. Does that make sense what I'm trying to get at?
Yes, and you're asking me to document or prove that we're going to hit the revenue estimates. I'm going to tell you what I know. What I know is these estimates were incredibly conservative. So even with the delay of rollout, even with cutting the fines in half, I am very confident that we are going to hit the revenue estimates. Hard stop. Our priority with priority bus lanes is about efficiency. It's about getting people where they need to go faster. And, the fine amounts is about equity. So we often are conflating revenue with safety and the purpose of doing it. I think we need to make the right decisions up front in terms of the amount and in terms of the value of it. And the fact that there is this sort of positive externality that revenues get raised, great. That shouldn't drive our decisions. And we're going to hit those estimates.
Okay, but I really don't think you can tell me, though, that the revenue from enforcement is an externality when you balance an entire fiscal year budget off of ATE revenue. So it's not a theory of asking about this. We have a budget that was passed. We want to make a change. I'm okay making a change. I just have to know that it's paid for. That's what I'm trying to get at. So if the chief financial officer can say, yep, this is something that we're going to be able to pay for, that's not the problem. The problem is the hesitancy of being able to move forward with enforcement on drivers over the efficiency of moving these buses. That's what we want. And it should have happened earlier. If this is new information and now there's a different change and a different answer this morning about why we're not moving forward with it, okay. I just want you guys to get this thing going because it's been too long. And it will move buses faster. It'll move our residents faster. It'll move our workers faster. But I got to make sure it's paid for if you're asking me to make another change.
Okay, and we are starting November 15th. I think within 30 days, we're going to be able to have a lot more understanding of what the revenues look like. And again, during the test period, 80% of the fines, of the warnings were tied to the area that we are starting fines in 2 weeks. So I think we are not going to see a big dip. While I have the microphone, if I may address something else that has been discussed, and I feel like we did not fully explain some of our position, but I don't want to do that if you've got more questions on clear lanes.
The only thing on clear lanes is I need for us to follow up quickly then to make sure that the CFO has the same conclusion you do, that this is somehow not going to touch revenue in a way that is problematic. But what is the other issue you want to bring up then?
So we spent a fair amount of time in the questioning about the merits of using points. And I fear what you heard a lot of was one of the downsides, which is very administrative. Like we have to get good images. We have issues with reciprocity. If we don't ID the driver, we're limited DC, all those things. Those are valid and clear. I think rather than trying to solve that problem, I wanted to make sure we were clear on some of the other issues with it. Particularly if the question is, do we do points in lieu of fines? And the impact of a fine is that for every violation, you are going to have a fine incurred. If we are dependent just on points, you need to get 10 or 11 points to get your driver's license suspended. So that would just mean that it diminishes. You can kind of rack up a number of violations before you feel the pain. So that was one point. And then the third one, and I think you've really nailed it on the head when you said, we have got to figure out a way to get to the subset. It's a very small subset of extremely dangerous and reckless drivers. I know that is the intent of your bills, and I know that that is a goal for all of us here, and I just want to make sure that we are focused on the lever to do that. And points, I worry that if we put too much energy on points, the subset who don't care about fines, the subset of our drivers who are driving 100 miles an hour on East Capitol at 3 in the morning, they will not care if their driver's license is suspended. And so I want to make sure that we're being surgical, because we could go to a lot of effort to make the points work administratively, maybe legally, but that I don't know if that's getting to the target audience. So I just wanted to make sure we were clear that it's bigger than the administrative hurdle.
I appreciate that, and I think that's also why we spent so much time too with both with Director Robinson and with Director Spriggs of the tools and mechanisms by which we then get that vehicle that person at 3 o'clock in the morning is driving through to get that vehicle off the road and out of their hands, because it's a tool they're using that puts so many other people at risk and so many people at danger. So I look forward to working with all of you, all four of you, and your staff to help craft these bills as they move forward. And so I want to again thank all of you for your testimony today, and appreciate that, as well as the work from your staff in the run-up, and I know as the follow-up to this as well. So I don't have any further questions at this point, so I think this is a good time for us to conclude the government witness portion of the committee's joint public hearing on Bill 25-421, Bill 25-422, Bill 25-425, and Bill 25-435. The next meeting of the Committee on Transportation and the Environment will likely be to mark up some combination of these bills being considered today. However, we have not formally scheduled the markup date yet, so stay tuned for an update on that timing. And there being no further business before the committees, The time is now 2:10 p.m. and this joint public hearing of the Committee on Transportation and the Environment and the Committee on Public Works and Operations is now adjourned. Thank you, everybody.
Thank you, Mr. Chairman.